Good morning, good morning, good morning. It's Tuesday, it's April 8th. We are going to Idaho today because there is so much to talk about, and we have lots to cover before the hearings in Idaho on Wednesday, April 9th and Thursday, April 10th. The court has set aside 2 days. I'm wondering if looking at these motions, if it will be more than 2 days, because what is anticipated in Idaho is continued argument in the Bryan Kohberger prosecution over not just the death penalty, but also we will see argument over the evidence in motions in limine. We have talked about the motions in limine in other cases that we've covered. For some of you, you're like, I thought jury selection in this case started in August. Correct. Judge H in Idaho is like, we're going to get out ahead of this and give ourselves plenty of time. What we're not doing is deciding evidence on the cusp of trial. This case has been pending for years. We are not going to wait. We are going to get this started. Today, we are going to look at a number of the motions in limine, but not all. There are so many of them. We will hear argument on them over the next 2 days. I'm going to cover the ones that I'm curious about and interested in. Some of them are going to be pro forma. Some of them are being made because you have to preserve it. So we're not going to go over the ones that are just like the state or the defense says this, and then the other side says that, and then the judge is going to do this. There's no need. We're going to look at some of the ones that give us more information. Because if there's anything known about the prosecution of Bryan Kohberger, it's that we don't know a lot about this case running up to this going to trial. And so I tried to pick the motions that would give us some more information that I was curious about. But also, chat, we have some updates in the TikTok psychic case. And I thought that since we're already boarding a plane to Idaho, we might need to just cover both. So we will go over the TikTok psychic updates first. If you don't know about this case, don't worry. I will loop you in. So we are going to cover that first. Then we'll go to the motions in limine. Replay crew, as always, love you the most. There will be timestamps down below. So you can just go pick the motions that you want to hear about the most. We're going to go over them. But we are going to talk TikTok psychic first because of course we're going to. And for those of you like, Emily, what's going on in the Karen Reed case? Jury selection. They're in jury selection. They're in, seat or yeet, picky, guessy, choosy. They're in jury selection. Yesterday, they seated no jurors, so they're still at 10. It's just going to be what it is. Some days might go quick. Some days might not. If you have the Lawnerd app, if anything earth-shattering happens, I'll let you know in the app. But I'm trying to get unpacked from my last trip so that when I start trial coverage, I actually can find things in my closet. I'm trying to make sure that I'm ready for trial to start because they are long days, they are busy days, and other stuff kind of falls to the wayside when I'm covering a trial like that. So I'm trying to make sure that I'm ready and you're ready, and we just needed a break. So we're going to talk Idaho for the next couple of days. That's what we're going to do. So Zero said, oh my God, it's still going. Oh yeah, the jury selection in that case, the judge estimated 3 weeks. And then the first week was like zoom. And then they came in over the weekend and were like, so they are, until a jury is sworn, it's going to go like this, because there are times somebody's going to get seated on a jury. They're going to go home. They're going to be like, I was seated on the jury. And then they're going to go, shit. And then the next day they're going to come in and be like, Your Honor, I forgot I've got this. When you haven't sworn them yet and they have overnight or over a weekend to have the realization sink in that they're now on a jury, sometimes you just, you start losing people the longer jury selection goes. So we'll see what's going to happen. So tomorrow and Thursday, we will be in Idaho for the Kohberger hearings, unless somehow we get to opening statements. That's really the only thing that I can see that would interrupt this. So that's where we're at. I don't see us getting to opening statements Wednesday or Thursday. Then again, who knows? Joe Jersey asked, is the TikTok mess going to be televised? No, it's not. But Idaho is lovely. Idaho is lovely. It is. So we are going to zoom. For all of you that are asking about breaking news, we will cover it a different day. Do not worry. I'm trying to go in order of the things that are coming up. And tomorrow, since we are in court in Idaho, this is what's getting covered today. So we are going to just do that. Let's roll the intro and let's roll the intro. Let's get into TikTok Psychic first, and then we're going to go through. Well, we're going to go through a number of the Kohberger motions in Limine. We're not going to go through all of them. We are not going to go through all of them that I go through today, line by line. I simply don't have time. We don't have time. We just don't have time. But we're going to go through more of the factual arguments and a little bit of the law to see what they are arguing. And then we will hear more of the legal arguments in court, because Judge H, I think, does a really good job of just saying, I've read your moving papers. Answer me this question. And so that's what we'll see. I want to make sure we have the factual background as we get into those hearings. So let's roll the intro. Let's get going. Law nerds, good to see you. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
So with all of you asking what's the breaking news I was talking about, well, it is Rex Manning Day. So law nerds, happy Rex Manning Day. No, that's not it. There is stuff going on in other cases that we cover. Don't worry, we'll get to it. I have been tracking it. We'll get to it. It's going to be fine. But it is Rex Manning Day. So not on Rex Manning Day, folks. Wolf Hart said, EDB, what can I expect from a grand jury? I was summoned for the summer. Ooh, Wolf Hart. Look, I have talked about this numerous times, so I'm going to try to truncate my statements. Grand juries can be either two fashions. One, it can be like the Diddy grand jury, which is you come in, they present you a bunch of evidence, and you indict or not indict, depending on location. And you do not need to tell us your location. Depending on location, sometimes you will get to choose what you indict a person on or not, and say, I think it's this charge, that charge, or whatever. Sometimes it's a more investigative grand jury where they bring you some information and say, what else do you need to see? And then you get to go give me the tea and ask for more records, phone records, witnesses. And you as a grand jury get to continue to investigate a case and ask for more information and come in one or two, maybe days a month, and then keep coming back. There's lots of different ways grand juries can run, but grand juries are fascinating to me. I would love to sit on a grand jury. So it could be an incredibly interesting experience. So just roll with it. And if you want to Google your location, depending on if you were summoned for a state grand jury or a federal grand jury, you can kind of Google where you are and get a sense of how they impanel grand juries and how long you might serve. But serving on a grand jury in most jurisdictions will be a period of time, and it will not be every day. Just 100% do it. Look, I understand that for trial juries, it can be hard. There are people who are like, I do not want to sit in judgment of someone. I know if we convict them, they're going to be sentenced to something. That's hard for me to do. With a grand jury, you're just the start of the process. You're the beginning of the process, and the courts take it from there. So it really can just depend on the type of grand jury duty. Some grand juries will sit for an entire week and you hear a bunch of different kinds of cases. Sometimes you're investigating one thing. Do it. Everyone in the chat, by the way, we mustn't dwell. No, not today. We can't. Not on Rex Manning Day. If any of you are like, Emily, Rex Manning Day, what are you talking about? Watch Empire Records. Damn the Man, Save the Empire. First of all, cult classic. Second of all, fantastic movie. Third, it just brings back my teen years. I love Empire Records. I love it. It's such a good movie. So for all of you that haven't seen it, go ahead and watch it. Also, Jayhawk Julie, because I do have a friend named Warren, this comes up quite a lot. Stop calling me Warren. My name's not fucking Warren. I can't. It's one of my go-tos. Like, it's one of my go-to watches. It's just, I think I'm going to call my band Mark. So good. So good. All right. So for all of you that need a 90s movie, go check out a 90s movie. It's good. It's good. It's good. It's good. All right. For all of you that are now, I'm going to like delve down into talking about Empire Records. The soundtrack is great. It's got everyone you're going to recognize from the 90s. It's just, it's a really, it's a fun movie. It's a fun movie. And it also touches on some really heavy topics, but it does it in a way where you walk away from the movie being like, I've felt something, I've learned something, I've listened to good music, I feel young, I feel old, I feel hopeful, damn the man, save the empire, like all the things. All the things. I love it when they used to make movies that didn't have established IP that were just great movies. Just a good movie, good acting, good story, good sound, day in the life of working at a record store. And for any of you who had like teen jobs in the 90s where most of the people you worked with were teenagers or young adults, I think you probably relate. Sinead Rebellion. Shock me with that deviant behavior. It just, again, and I don't think jobs are like that anymore. Well, HR departments, but I don't think jobs are like that anymore. Maybe they are. It's just the things that pop off at a job when everyone that works there when everyone that works there is a teen. It's just fantastic. You guys are making my day. What's with today? Oh yeah, and Guar. So good. I also wish I worked at a record store when I was a teen. However, working as a lifeguard had the same vibes. And look, I love that what you guys aren't in here in the chat yelling at me is chicken jockey. So I'm thrilled that we're getting to, talk about what's with today, because we could talk about Minecraft another day, but every generations need their movies that just kind of speak to them. And I love that. And Empire Records is one of those kind of slice of a moment movies where, it makes me nostalgic now. I'm just like, ugh. High Fidelity, also a great soundtrack. Back when movie soundtracks were iconic and were everything. Okay, let's see. Jordan said, EDB, as someone who grew up with Minecraft, I expected it to be a bad movie. I will still enjoy it unbelievably. My kids are on the same page with the Minecraft movie where they're just like, I expect it to be cringe and I would love for it to be cringe. They're just ready to be seen. And Grosse Point Blank. I like Reality Bites. I love Grosse Point Blank. Also a great soundtrack. Speaking of movie soundtracks, I have a soundtrack. I need to start making soundtracks on like YouTube Music to just share with y'all. I keep meaning to do that. ADHD. Like I get distracted by other things. But I have a Shaun of the Grosse Point Blank soundtrack that blends the soundtrack from Shaun of the Dead and Grosse Point Blank. It is such a good soundtrack. Such a good soundtrack. But before we get into the soundtrack of my life, we need to talk about the TikTok psychic, or I'm just going to sit here and talk about music with y'all forever. Yesterday, I looked at my husband and was talking to him about concerts that we want to go to and trying to figure out if we're going to be able to get to Los Angeles to see Yachtly Crew, because Yachtly Crew and Say Ferris are going to be playing together. Like, are you fucking joking me? I'm like, immediately yes, but also flying to LA over Thanksgiving, like, just nothing sounds worse. But also Yachtly Crew, Say Ferris, like there's a balance of like how much travel pain I'm willing to go through for music. And my husband's like, you've been on calls all day, because yesterday, all day calls. You've been on calls all day and you say you need to pull documents and like prep the podcast. And it's like 8:30 at night and you're starting your prep now. Concert tickets. I'm like, you're telling me that I can't just ignore my adult responsibilities and spend the rest of the evening shopping for concert tickets and plane flights. He's like, you need to just be ready to stream tomorrow. you need to just be ready to stream tomorrow. Tomorrow you can buy concert tickets. So when I am done here, friends, when I am done here, I am going to be planning out more concerts because live music makes me happy. And some people are like, if I don't have another stamp in my passport, I can't persist. Like, I need to know where I'm traveling in the next 6 months. That's basically me with concert tickets. If I don't have a concert ticket in the future somewhere, I need the dopamine. Like, we're just working concert to concert. It's concert season. I'm ready for it. I'm just ready for it. All right. Let's talk about TikTok Psychic. So I guess today's stream is short. Compared to other streams, maybe. Look, tomorrow's going to be a full court day, and so is Thursday. So we've got 2 full court days coming up. So today is going to be relative? Like, it's relative. Let's pull up the goings on in the TikTok Psychic case. I'm going to give a road so far real quick. Let me open. No, open. Thank you. All right, let's go to Idaho first. We have not EDB aired in a minute. Let's go to Idaho first, and we'll do a road so far, shall we? If you are new to the TikTok Psychic defamation case, there are times where I have cases that I feel strongly about. They are generally cases after trial. Well, I'm like, this is my thoughts on this. But there are some cases we come across where I'm like, from the outset, I have thoughts on this case. This is one of them. I have thoughts on this case. This case enrages me. But I don't blame the plaintiff. They had no other option but to sue. My frustration is that the plaintiff in this case had no other option but to sue. It shouldn't be that hard to send a cease and desist and be like, hey, you can't just accuse people of murder without any freaking evidence of that. You can't just be like, vibes, you're a murderer. It impacts people's life. I think there's no hyperbole to that. It is an accusation. And when someone is representing themselves, as the TikTok Psychic is, when they are representing themselves, they don't have the monthly reminder of their attorney's fees to, I don't know, incentivize rationally resolving a case. But before you say, well, maybe the TikTok Psychic believes what they say, the TikTok Psychic believes they have the right to say what they say. There are limits to that. You cannot accuse people of crimes. It's defamation per se. There are boundaries to that. So even if you're like, well, I think it's true, therefore it's true, that's not going to be good enough, because accusing someone of crimes is not an opinion. Saying that you think somebody's behavior is abhorrent, or saying that somebody's acting like an asshole, that might be an opinion. But accusing someone of crimes is not opinion. So there are boundaries, and it's frustrating because when the TikToker comes into court, the TikToker's gone after the judge, who has been indelibly patient, and comes into court and says, the court is impeding my freedom of religion because they do not believe that my tarot cards are objective evidence. Well, I have no problem if you want to read tarot. I do have a problem if you want to bring that into court and say, see, this proves that what I said is true. That's not going to work. So we have seen some very cogent and logical, though misguided, arguments from the TikTok Psychic, who refuses to take any responsibility. Procedurally, where are we at? Well, the court granted a motion for summary judgment as to liability. This is a civil case going on in federal court. Liability means the court has decided based on all the evidence before it on summary judgment, that the TikToker is liable for defamation. The only thing left is for a trial on damages. So this case should be set for trial on damages. The TikTok psychic does not want, it seems, to go forward on a trial for damages. The judge has been so patient. And the frustration with the legal system is that the remedy here is difficult and arduous and tedious and somewhat insufficient. Nothing really is going to stop the TikToker from saying whatever the fuck they want. And how do you make someone stop saying whatever you want? Like, what do you do to them? Especially when people feel like they are judgment proof. It's like, you want to take my house? I don't have a house. You want to come after my bank account? There's nothing there. You want to garnish my my earnings from TikTok? Well, TikTok yeeted me off the platform. What are you going to do? So it becomes difficult for the plaintiff who is trying to follow the linear path to resolution when the other person's like, so what? Make me. What are you going to do? So what? Make me. And that's where I get torn about talking about this case. And the reason I refer to the TikToker as the TikToker, because we're not putting anything on her name. And I don't want to bring more attention to any platforms she may still have, because I think the best thing that can happen is for this creator to be ignored. And I think that's the only way they go away, is to ignore them, not to engage with what they say in their content, not to give them attention, even if it's negative, because a lot of people around the internet don't give a shit what form the attention takes. Like, as long as you're talking about me, you're talking about me. So the best thing I can think of is to ignore them. Nikki Crayons, the 10 out of 10, just fade away. 10 out of 10. And I think that denying someone the attention that they are seeking is maybe the only thing that we can do, which is why I'm torn about talking about this case. However, I think it's also important to follow how difficult it can be, even in the face of something ridiculous. At the beginning of this case, many of you asked, why can't this case just go away? Why is this case even in court? This seems so obvious. It seems so clear. Well, the plaintiff is the one who's been harmed here. And I'm not saying allegedly, because we've got a summary judgment motion finding that these statements were defamatory. The plaintiff is the professor at the university who's been harmed. And what else can they do other than sue? They sent cease and desist. They said, you need to knock it off. They said this isn't true. And still the TikToker is like, no, I said what I said and I'm right. So tough shit. So what does the plaintiff do? And the court can't just look at a case and say, ridiculous, and say, obviously this person did the wrong thing. There's still process that has to happen, and that process can be slow. And I think that that's valuable to talk about. And the damage that's done to the professor's reputation, if any, and we'll see when we get to damages, the fact that this professor's name will always be linked with not just this lawsuit, but with everything this TikToker said forever, can have career impacts down the road, can have other impacts, and can have psychological impacts. When people are calling your job and leaving you threats, it impacts people, especially when somebody is a private person. They got dragged into the spotlight during a time when their community was grieving and dragged through the media and the mud and suffered the impacts of all of that attention of the internet on them. And by the time this gets resolved, it's not going to get covered by myself and maybe a handful of other people on YouTube. it's not going to get the headlines that it got at the beginning. And that's where I'm still covering this case, though I don't want to bring more attention to the creator in this situation, because it should be known that the professor's already won a part of this case. I haven't seen any reporting on that other than mine, really. So that's where I'm torn on this, and that's why I wanted to share why I'm still covering it. I hope maybe at the end of this, some of those articles that were written years ago will have a note at least saying that the professor won their case and won an amount of damages. I really hope that happens at the end of this. We'll see if it does or doesn't. So let us go to, and I was waiting for all of the briefing to come in together. So we have the updated joint status report of the case and then additional briefing. So let's go to that. Jordan said, this is a great question. With a judgment-proof defendant, what can the court do? Could the court issue a gag order and then find the psychic in contempt with fines or jail? It's a tough situation. That is a gag order, no, but an injunction, yes. We saw an injunction asked for in the Cardi B defamation case. So yes, that is an option. This becomes difficult because the TikToker does not live in Idaho. So this becomes a difficult thing to enforce because they are also outside of the state. So it's hard. It's hard. All right, let's continue on with what's going on. There's no easy answer. And even if you win a judgment, then it becomes almost a second lawsuit, and we have not peeked back in on the Cardi B case. But once you win and you win a money judgment, it becomes another lawsuit starting at the beginning to collect that money. So it's not easy. And even if you win, you still don't win. Sash asked, can they put the TikToker in jail? No, it's a civil case. Monetary damages. It would take quite a long way to get to the violation of a court order where contempt would warrant jail, and you can't put someone in jail for not paying fines. It's not easy. So even if you win, you still lose with the initial damage being done and the amount of legal fees. So it's not an easy win. So Mibby, I love that. All right, let's get dangerous. Emily, are you going? No, we're not going to stop. Can't stop, won't stop. Let's see if we can get this document to do what I want it to do today. All right, we'll try. We saw how that went the other day when my documents were just not playing nicely. So this is from March, I believe, pursuant to the court's order on, March 11th. Pursuant to the court's order dated February 19th, the parties submit the following joint status report. Plaintiff professor's position. Professor Schofield asserts that this case is ready for a trial on damages only. As the court has already determined as a matter of law that TikToker defamed Professor Schofield. Professor Schofield anticipates needing 4 days for trial. Her preference would be to have the trial in August 2025, which will afford the parties sufficient time to prepare and accommodate counsel's other pending trials. Professor Schofield has tried to determine whether TikToker is available for trial in August and whether TikToker agrees 4 days is sufficient. TikToker has not answered either question, instead indicating she plans to file a motion to change venue and a motion to stay trial until after the state court trial in the state of Idaho versus Kohberger. Trial in that case is set for August 11th. Professor Schofield opposes both of the contemplated motions. Before proceeding to trial, the professor is agreeable to participating in a judicial settlement conference. That's not going to go very far. That's not going to go very far. That's not going to go very far at all. The professor is agreeable to a judicial settlement conference. She has communicated this to TikToker. TikToker, remember, representing herself, however, has indicated she plans to file an appeal in this case and thus will not enter into any settlement that requires payment or admission of defamation. She doesn't have to admit defamation. It's already been found. She doesn't have to admit it at all. She just has to go to trial on the damages. Given TikToker's position, Professor believes any judicial settlement conference would be unproductive. Facts. 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 It doesn't matter if the judge says, okay, well, let's talk about how this case might resolve. If the TikToker is like, no, I still think that I'm going to win. Again, there's no winning here other than paying less damages. That would be the win because the liability's already been settled. Defendant TikToker's position, considering newly received evidence. We can see where this is going. TikToker will proceed with a motion to stay proceedings until after the state court trial of Idaho versus Kohberger to avoid conflict of interest with potential witnesses and to allow for the unsealing of evidence that supports TikToker's affirmative defense of substantial truth. That ship has sailed. Liability has been determined. Period. Substantial truth is no longer on the table because there's no longer a defense because liability has been determined. The only witnesses are witnesses that go to damages. That's it. And those expert witnesses that would go to damages are just going to not be involved in the Kohberger case. TikToker initially agreed to participate in a judicial settlement conference with the boundary that damages to the professor and admission for defamation be excluded as solutions. What? A judicial settlement conference is a conference with the judge and the attorneys to try to resolve a matter before it goes to trial and have that conversation candidly. Since the matter of liability is already determined, admission of defamation is not needed. You've been found to have defamed. Payment is what's next. The only question that remains is in what amount? That's the pending question. TikToker goes on to say, however, considering newly received evidence supporting TikToker's statements, a judicial settlement conference intending to provide the plaintiff with relief would be inappropriate. Wrong. Dated March 11th. Great. So you can imagine what happens next, right? You can imagine what happens next. Yep, the TikToker makes another motion. Let's open this up. The TikToker makes another motion for reconsideration. This defendant has continued to needlessly extend the litigation with motions that are not well taken. Finn asked, is this really about the spiritual witness again? Yes. Yes, this is about the spiritual witness again. However, this individual is not a lawyer. So it's not like the state bar can say, hey, you're filing frivolous motions. They're not paying their lawyer to file all these motions. A lot of people would look at their lawyer and be like, okay, well, can we pick the things that are the most needed? It's hard to say that this is an intentional frivolous filing, even though it's getting there for me. This judge is more patient than I am. So we're just kind of stuck in this loop where the legal fees are being racked up for the plaintiff. And I have to wonder, and this is purely my speculation, I just have to wonder if the goal of this plaintiff is to make this so uncomfortable, or the goal of this defendant, TikToker, is to make it so uncomfortable that it all just goes away. It's like, fine, I'm just gonna fight at every single turn, every single way until you stop. We're just gonna try to run you out of money. It's frustrating. It's frustrating to watch. Defendant's Rule 60B motion for reconsideration of partial summary judgment. And again, this pro se defendant realizes that there's a summary judgment motion, yet in the last motion said, I'm not admitting liability. You know that liability has been found. You know that it's been found. Zuna, what happens if she doesn't pay? Then they have to try to garnish whatever can be garnished. And she could attempt, I don't even want to put that out there. I don't want to give anyone ideas. I'm going to be quiet on that. I think that no matter what award comes at the end of this, it sparks a second fight to go after the money. Awkward Aquarian says, does the professor have to respond to each of these motions? Yes. Yes, they do. Sassy Hound, I didn't look at the anti-slap laws because they moved directly to summary judgment. So the summary judgment's already done. Anti-slap kind of bumps in like California. It terminates the lawsuit earlier on than a summary judgment. But because the defendant didn't engage in discovery, the summary judgment motion came pretty early on and terminated the liability portion of this. So this is not an easy road. All right. Comes now, defendant, and moves the court for release from the order or relief from the order granting partial summary judgment. Again. On motion and just terms, the court may relieve a party or its legal representative from a final judgment, order, or proceeding for the following reason. 2. Not 1. This reason. Reason 2. Newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial under Rule 59B. The dockets and evidence provided by the state court trial in State of Idaho versus Kohberger provide factual support that substantiates the TikTok videos defendant posted regarding the murder of the 4 University of Idaho students at 1122 King Road in Moscow, Idaho. With newly discovered evidence, Gouliard cannot legally be found liable for defamation because the evidence proves that she was one telling the truth in many of the videos. If your defense is a broken clock is right twice a day, it doesn't reduce your liability for defamation. One statement can be defamatory. Telling the truth in many of the videos. And 2, not proven to be false in others. Prove it. Prove that you're not a murderer. Prove it. And she has done this consistently throughout this case, saying the standard is you have to prove that I'm lying. So prove it. She goes on to say, additionally, there is outstanding issues of material facts. No, there's not. The fact portion of this case is closed. She's trying to reopen it. Let's continue. Memorandum in support of the Rule 60B2 motion. We'll talk about the propriety of a Rule 60B2 motion when we get to the response. Newly received evidence derived from credible sources who establishes beyond dispute that 1, the TikToker's TikTok videos regarding the professor and the murder of the 4 University of Idaho students in Moscow are substantially true. We're going to go through a lot of evidence today. You know what none of it points to? Professor Schofield. 2, the remaining TikTok videos regarding the homicide have not been proven false. 3, there are several outstanding issues of material facts due to the complexity of this civil case and the connection to the criminal case. This civil case isn't complex. It's just about damages. The 3rd and 4th elements of a defamation claim require that the published information was false and that the defendant knew it was false or reasonably should have known that it was false. This gets into whether or not the professor's a public figure. The professor's not a public figure, so information was false. Evidence supports that TikTokers' videos regarding the quadruple homicides are true. That's not true. I'm going to see her argument, but that's just not true. Plaintiff Professor Schofield fails to meet the falsity requirement of a defamation claim in Idaho. Just like when I was screaming about Special Prosecutor Carrie Morrissey trying to just relitigate the same shit over and over again, you can't just say, no, but Your Honor, you're wrong. And the court's like, no, I'm not. We've gone through this like 3 times now. And the court's like, no, I'm not reconsidering judgment. And she's like, right, but you didn't hear me. You're wrong. And the court's like, no, I heard you, but I'm not wrong. And she's like, no, let me tell you again. You're wrong. The circular arguing is so fucking frustrating because there is no linear logic coming into this. All of it is circular. And if you have ever argued with someone who does this, you know exactly what I mean. It's just like, they're like, A. And you're like, okay, let me answer A. And they're like, ugh, but B, and also you're wrong. And then you're like, okay, no to B, but also I'm right. And they're like, C, D, E, also you're wrong. And it's just around and around and around and around. And there is no way through this. And the court putting their foot down has still not stopped this argument of, no, but I'm right. But you're not. And there's no amount of logic that is going to move this forward. And there's no lawyer in the equation to sit down with a client and say, this is never going anywhere. You are going to continue to lose. And there's no motivation monetarily to say, and if you continue to lose, this is how much you're going to spend. Because the TikToker's like, I don't care. I don't care. Terry Needs Coffee said, at what point could the court actually do something like, I don't know, but what do you do to stop this? The court granted the summary judgment and the court has denied each of these motions. At some point, will the court just start striking these motions and saying this motion is untimely? Maybe. Christine from Oz said, can the court commit her for a psychological evaluation? It's not a criminal case. It's a civil case. And she's the defendant. So no, the court can't. And this is obstinance is a choice in this case. So this is an ongoing choice. Valerie said, doesn't filing motions cost money? Yes. However, I think she has some of a fee waiver on that. This is very much bordering like the sovereign citizen arguments, but not quite there. So again, we're back to the argument of prove that I'm wrong. Like, prove that you didn't murder someone. Prove that you didn't. McLeod in the chat asked what many of you ask in the chat every time I cover this case. Isn't there anything criminal here? No. No, there isn't. No, there isn't. It just, I think it highlights the frustration of what the professor has to fight in a case like this. And I also hope that it highlights, because there's a lot of times we see things go down on the internet and we look at them and go, well, why doesn't somebody sue? This is why. This is why. This is why. This is why someone doesn't sue. We are not going to see soft sit arguments here because she has doubled down on religious freedom. And so you can't do both, because if you say these rules don't apply to me, you can't say, well, then my rights are being infringed upon, because you're saying that those laws in the Constitution don't apply to you. So, Mimi in the chat said, will this delay the criminal case? No, the criminal case doesn't give a shit what's happening in this case. And this case really shouldn't give a shit what's happening in the criminal case. A lot of you have asked, when does this cross the line of harassment/bullying? These are court documents. So we're not there. This individual is saying that they are going through court process, though I think they are starting to reach the boundaries of excessive or frivolous motions. The court can stop them from filing motions without permission of the court. That would be the next step. The next step would be the defense cannot file a motion without leave from the court. That would be the next step to slow this down. And maybe that's what needs to happen. But the TikToker isn't filing lawsuit after lawsuit. So we're not getting into that kind of vexatious litigant. She's the defendant. And she's the defendant because she got the cease and desist and was like, I'm not doing that. So then if you're the plaintiff in this, what do you do? Emily Ippolito said, has she continued her campaign on TikTok? TikTok took her off of their platform. I think that's the only way to stop her, is for her to not have a platform. But then again, if she doesn't have a platform, there's no way for her to make money, seemingly. And how does the professor recoup anything? Which is why I continue to cover this case, to point out the frustration. And there are oftentimes reasons when people are like, could I sue for defamation? Yes. But when you look at the cost benefit analysis, is it worth it? Probably not. Again, letting someone just not have a platform that people pay attention to is probably the best option in a case like this. All right. The TikToker goes on to say that evidence supports that her TikTok videos are true and that the professor didn't prove that the defamation claim was false, and that because the TikTok videos have already been proven to be accurate and supported by evidence, that the clear cognizant abilities, oracle card readings, and tarot card readings are plausible. Look, your assertion that these things are plausible, if taken as true and if could be used as evidence, if, and none of that's true, but if, that still doesn't get you past a defamation claim, because it could be true. Kimberly said, will a guilty verdict against Kohberger open up the professor's ability to go after the psychic? That's where we're at now. The professor has gone after the psychic, or the TikToker. The professor has gone after the TikToker, and that's the boot loop we're stuck in. What happens in Bryan Kohberger's case is specific to Bryan Kohberger. Bryan Kohberger's case isn't going to somehow unearth that the professor's at the heart of it. If it does, I think that would probably change things. But I don't see that happening based on everything we've seen in that case. And that's what would have to happen here. So whatever happens in Kohberger's case, it doesn't really matter to this case. The state being able to prove their case against Bryan Kohberger doesn't change that the TikToker cannot prove that her statements about the professor are true. So because the TikToker cannot prove that her statements about the professor are true, the guilt or not guilt of Bryan Kohberger doesn't matter. Unless evidence is unearthed that the professor is involved. And I just don't see that happening at all. TikToker says that her own claircognizant abilities. Look, if you could just come into court and say, because I said so, it makes it true, we wouldn't really have a court system. There has to be additional evidentiary support for a claim. But she says that her oracle card readings, her tarot card readings are plausible, consistently reliable, and must be taken seriously. This is a court of law. There are rules. Chat, all of you are like Ipsy Dixit. Exactly. But Emily, Ipsy Dixit. It goes on to say, that there are outstanding issues of material fact. No, there aren't. The fact part of the case is closed. I'm not going through the background again with the TikToker making the allegations that she keeps making. Also, she seems to keep arguing like TikTok privilege. She's like, but somebody asked me to look into this, Your Honor. This wasn't my idea. Someone on TikTok said you should look into this. So she used her spiritual intuition, claircognizant abilities, tarot cards, and oracle cards to investigate the cause of the homicides. And that her psychic investigation discerned that the 4 students were the victims of a murder plotted by a history teacher who co-planned, hired, and executed the murders with a male student, and that she then conducted tarot card and oracle card readings on the staff of the University of Idaho's history webpage. And those readings pointed her to the professor. And she reported that information to the FBI tip line. If she had just reported that to the FBI tip line and nowhere else, we probably wouldn't be here. Technically, could that be defamation? I think it's going to depend on case law in each jurisdiction about whether reporting something to the police is a publication. And I think it would depend on what happens from there. Law enforcement actually put out a statement because of these videos saying that the professor was not involved. Because of how much traction this gained, law enforcement was forced to address it. On December 12th, 2022, TikToker received 2 demand letters dated November 8th and December 8th by email from the plaintiff's attorney. The letters demanded that TikToker cease and desist false and defamatory statements. TikToker refused to comply. This is accurate. Refused to comply with the demand letters because she contends that the information that she published is substantially true. It's true that there were 4 murders. But yeah. Let's see. This is going back. This is cut and pasted of the background that we've seen before. On July 13th, TikToker issued a subpoena to Meta Platforms, Inc. to produce documents and information relating to plaintiff's social media activity with University of Idaho students, connection to the 4 students and alleged co-conspirators. On July 27th, plaintiff filed a motion to quash. On October 6th, the court granted the motion to quash the summons and informed Meta Platforms not to comply with the subpoena. On October 10th, plaintiff moved for partial summary judgment based on defendant's complete failure to respond to plaintiff's earlier served request for admissions. Accurate. Defendant responded to the motion for partial summary judgment, stating she never received the request for admissions. I don't believe it. During the status conference, the court gave Gouliard more time. While pro se defendants are supposed to be treated the same as lawyers, the court often gives grace. And the court has given a lot of grace here and gave Gouliard 7 days to respond to the request for admissions. We went through this. The court then allowed for an amended motion for partial summary judgment. The TikToker basically said in her responses, I said what I said, and you can't say it's not true. But that's not how it's going to go. The court then allowed the amended motion. On January 12th, 2024, plaintiff filed an amended motion for partial summary judgment, as well as a motion for leave to amend the complaint to add punitive damages. The court allowed all of that. On June 13th, the defendant rescinded consent to proceed before a magistrate judge. That didn't go well. And that was denied. On November 13th, the court denied the defendant's motion to reassign the case. You can't just be like, "Nuh-uh, Your Honor." On February 4th, the court denied the defendant's motion for reconsideration and to amend and correct the memorandum decision and order. Now before the court is defendant's motion for reconsideration again. She's going to go through the legal standard. She's not accurate on the legal standard. And there's a lot of times where she will willfully misinterpret things, it seems to me, and play quite a lot of word games to parse things, which is frustrating. We'll go through this in the response. So the TikToker says there are several material evidence and exhibits in the state of Idaho versus Kohberger case that corroborates TikToker's videos regarding the case and the professor's connection to the case. And she's saying the court may take judicial notice of public records. That's not what it means. Yes, the court can take judicial notice of public records, but argument by lawyers about what evidence may or may not be is not the type of public record. A power bill saying this house has a power bill paid by this person in this amount, yeah, that might be the kind of public record you can take record of. But fact-based records is not what that case means. This is not what that means. Based on newly received evidence, it is evident. We hold these truths to be self-evident. They don't. Oh, Emily, stop singing Hamilton. Griffin is deeply into a Hamilton moment. And look, man, if Lin-Manuel Miranda writes it, it's probably going to get stuck in my brain at some point. That's just facts. Stuck in my brain. It is evident that redacted, sealed, and suppressed exhibits and evidence exist. How can you prove something exists if you don't know that it exists? We're going to get into a whole existential conversation. Just because something is sealed doesn't mean it is what you think it is. There are redacted and sealed exhibits. Suppressed is a loaded word in this context because nothing has been suppressed at this point. Victoria said, I'm surprised she hasn't filed a harassment suit. You can't file a harassment suit over what's going on in court like this, because these are all made in legal motions. So she is saying that because there is sealed and redacted exhibits, it proves that there's more evidence in the Kohberger case than she knows about. True. There's more evidence in the Kohberger case than this plaintiff knows about. It doesn't matter. And here's why it doesn't matter. What matters is the information that the TikToker had when she made the statements. When she made the statements, what did she have that supported the statements she made? And she has come back to the court and said, I'm omniscient. And that claircognizance is to be taken seriously. And the court has said that's not evidentiary support sufficient for court. So you need like objective evidentiary support. Some evidentiary support. And her evidentiary support has been, well, the way I interpreted my tarot cards says that it's her. Okay, well, your interpretation of whatever you want to interpret isn't objective, independent, verifiable evidence. So that's where we're at. So whatever has happened since doesn't matter. What did she have in her possession and knowledge at the time she made the statements? And they've done discovery, and the answer is nothing. And that's why we're here. Newly discovered evidence supports the videos are the absolute and substantial truth. Those things aren't the same. They're the absolute truth, more or less. It's not even what that's not what the words mean. On December 9th, 2022, TikToker posted a video that the surviving roommates of the homicides were afraid the night of the murders. You're telling me that survivors of a quadruple homicide may have been afraid the night that the homicide happened. And that means that the professor did it? Okay. That's not how that works. I know all of you are like, these are shocking revelations. These are shocking revelations. Shocking. I am not going to get into what else she said about the survivors. Anything she said about the survivors, whether or not it is true, is irrelevant to her defamatory statements. And saying, I speculated correctly about this situation that many could speculate about, isn't sufficient. And the surviving roommates, as this goes to trial, are going to have enough that they have to go through. They don't need to be dragged through this. James Randolph in the chat said, I heard the professor used a candlestick in the library. Right. She then gets into the text messages that have since been released in court documents. We're going to talk about those more later today. And we're not None of this helps her case at all, other than to say, see, Your Honor, there's more happening in the criminal case. We're not going through the propriety of whether or not the roommates were afraid. And then she continues to link the motions in Idaho and her own TikTok videos. On December 13th, she says she conducted a psychic investigation regarding a 2011 to 2013 white Elantra that Moscow PD suspected was connected to the case. They put out a press statement saying so. She posted the results on TikTok on December 13th and December 14th and stated that Professor Schofield had access to a white Hyundai Elantra the night of the murders. Remember, the professor was in Portland, Oregon, the night of the murders, not in Washington or Idaho. On January 12th, 2024, Schofield admitted to having access to a white Hyundai Elantra during the night of the quadruple murder of the 4 students. State's Exhibit A alleges evidence that the white Elantra was seen near the area of the homicide several times. We're going to talk about the car in a bit in the motions in limine. On February 24th, 2025, Kohberger's attorney filed a motion regarding the make and model. We're going to cover that later. The motion introduces the possibility of 2 separate white Elantras. Y'all are just lazy pulling the plot from My Cousin Vinny at this point. Identical. They've already written this movie. On November 25th, 2022, TikToker posted a TikTok video about the dog. Okay. That has nothing to do with the professor. Unless the professor had the dog the next day. Did the professor have the dog? No? No? Okay. On November 23rd and December 9th, 2022, 4 TikTok videos were posted stating that the killer was broken up with by the victim. On January 13th, 2023, the parents stated in an interview that the victim and an individual by the initials JD broke up a few weeks before the homicide. JD's interview is sealed. Okay. There are outstanding issues of material facts. Gouliard's statements have not been proven to be false. The problem is, there is no evidence to support that the TikToker knew her statements were true at the time that she made them, and that's what she is missing. She is saying it could be true. You have to prove that what you said is true when you said it and have evidence to support that. Because she's not retelling something different than other defamation cases we've looked at, where you have like a re-reporting, where it's like, this article says this. Okay, well, if you're saying this article says this, that's one thing. But she's saying, no, my psychic ability tells me that this is what is true. There's not even a way for her to argue this is opinion. And she tried that too. She tried to argue this is my opinion. It's my opinion that she committed the murder. That's not going to work either. You have to have evidence at the time that you said the shit that you said. So this isn't going to be a case where she can say, but I believed it, so therefore it's true. That's not going to work. She goes on to say that there are some statements in her videos that were correct about where the victims were found, and that this has been coming forward. On December 2nd, TikToker posted a video stating that law enforcement would announce someone as a suspect or make an arrest regarding the murder of the 4 students within the next 2 to 4 weeks. And someone was arrested on December 30th. I said they would arrest someone in this case, and then someone was arrested. That does not prove that what you said about the professor has evidentiary support. She goes on to say that there is more unsealed evidence that shows that she was correct and that she has not been proven wrong. That is not the accurate standard. Yeah. On January 2nd, TikToker posted a video that Kohberger was called to the scene of the crime by Schofield, but ultimately left without committing the murders. On November 13th, roommate testified that she saw a masked, that wasn't testimony, that was an interview, that she saw a masked man with bushy eyebrows walking towards the back door and that he walked past her but did her no harm. Okay. She goes back through some of the text messages and the things in the motions in Limine to say, see, I'm not wrong. None of these motions in Limine talk about the professor. On December 13th, 2022, TikToker posted a video that the professor does not have a valid case for defamation against her. Your Honor, I said on TikTok that this case is bullshit. How can you find me liable for defamation? On December 13th, 2022, TikToker posted a TikTok video saying that the professor does not have a valid case for defamation against her because she did not have convincing and substantial evidence that she didn't kill 4 University of Idaho students. And that the TikToker stated that they need a different murderer and a thorough investigation into the professor's connection to the murders by Moscow PD or the FBI, and a statement from Moscow PD or the FBI that Schofield isn't the killer, and proof that what Gouliard is saying is false. You don't get to just rewrite the law the way you want it to be and say she has to prove it now. I said it, you have to prove it. That's not where we're at. On December 27th, 2022, MPD issued a statement, quote, "At this time in the investigation, detectives do not believe the female associate professor and chair of the history department at the university suing a TikTok user for defamation is involved in this crime." And then Kohberger was arrested on December 30th. Based on the timing of the TikTok videos regarding the connection to the homicides, to include the fact that she had access to a white Elantra the night of the murders, the timing of the civil complaint, and the timing of the anonymous tip connecting Kohberger to the crimes, there's a possible connection between Schofield and the person who gave the anonymous tip. The anonymous tip gets all into the DNA stuff. So, no. Yeah, no. Also, the TikToker doesn't have any proof that when she made these statements, she knew of a connection. But she's trying to change the way defamation works to, well, prove you didn't. Prove you knew I did when you said it, not prove you didn't. That's not the standard. She goes on to say there are still outstanding issues of material fact. As to her case, that's not accurate. She is saying that the court has erroneously placed the burden of proof to prove that Professor Schofield caused the murder on the defendant. The motion for summary judgment has 2 prongs. And the court went through them thoroughly. I went through them thoroughly. The professor met the first prong. The defendant did not meet the second prong. And then she was found liable. TikToker says the court made an error of law. She's already made that motion. That's not going to fly. The court did not make an error of law. And she's saying, look, Your Honor, there's new evidence. That new evidence does not show what she knew at the time that she was speaking. So that's not accurate either. She goes on to say the evidence regarding the 4 homicides is controlled by the state of Idaho and is largely sealed and redacted. Hence, there are material issues of fact in this case. That's not what those words mean. As evidence regarding the events that took place the night of the murders is made public, the TikTok videos are consistently proving to be the absolute truth and substantially true. No. And that is beyond, she says, the parameters of coincidence. It is not evidence that you had at the time you made the statements. And this is the frustration in a case like this, is she is just going around and around and around and around. She goes, she's saying it is her burden to prove that the professor was involved in the homicides. It is reasonable for the court to wait until after evidence is made available to the public before any judge or jury can make the decision on the merits of the case. The merits of the case in this case have been decided, and it doesn't matter what happens in the criminal case. You have to prove what you knew at the time of speaking. I'm going to stop repeating myself. She goes on to say that her consistent accuracy proves that her videos were not published with malice. Malice isn't an element here. The professor is not a public figure. Additionally, because evidence supports the accuracy of her claircognizant abilities, she is reasonable to believe that she is capable of getting to the truth of the matter. No. The plaintiff has made several false statements about TikToker. Oh, Your Honor, she's defaming me. I really want the court to just say, stop hitting yourself at this point. She's like, I'm being hit. It's like, okay, stop hitting yourself then. She says that the professor has made several false statements about her and that she has not made false statements knowing they are false. She, defendant, did not make false statements knowing they are false. In fact, many of her statements are backed by evidence and absolutely true. She goes on to say, professor has not proven by the preponderance of the evidence that TikToker defamed her. Well, the court found that it happened. It is in the best interest of justice that the order granting partial summary judgment is completely reversed. And she is asking the court to do that. Let's look at what the professor responded to with that, because that's the next thing, is that she had to respond to the motion for reconsideration. So we will take a look at that next. Oh, I didn't pull it up right. We will take a look at that next. And then we're going to move on to all the motions for summary judgment. Not the motions for summary judgment. Emily, that's what we're talking about now. We're going to move on to all of the motions in limine. A lot of what the TikToker is trying to pull into this is stuff that's been publicly made available, and she's trying to prove it after the fact. And that's not going to work. This is the plaintiff's opposition to defendant's motion for reconsideration. Again, introduction. This is from the professor. For the third time, defendant asked the court to revisit a prior decision. But quote, the court's opinions are not intended as mere first drafts subject to revision and reconsideration at a litigant's pleasure, and then cites the case law for that. She says that the TikToker's current request for reconsideration, like all her others, is meritless after failing to show that the court's decision to grant partial summary judgment in favor of the professor was a clear error or manifestly unjust. Gouliard now argues that she has new evidence that warrants revisiting summary judgment. The motion fails for 2 reasons. 1, the evidence she submits does not affect the court's prior reasoning. And 2, the evidence she submits could have been discovered previously. The court should deny the motion. We are not going to go through the background again. We know the background of this. The parties are awaiting a trial setting to determine the amount of damages TikToker owes to the professor. The TikToker does not want to go to trial, they say, so she has repeatedly sought to relitigate decided issues. I don't disagree. And she has consistently tried to relitigate. She's like, but Your Honor, nuh-uh. I said that people were scared, Your Honor. Legal standard. TikToker moves under Rule 60B. That rule allows a party to seek relief when there is, quote, newly discovered evidence that with reasonable diligence could not have been discovered in time to move for new trial under Rule 59B. And then they go on to quote Federal Rule of Civil Procedure 60B2, saying reconsideration is an extraordinary remedy. Thus, motions for reconsideration are generally disfavored and may not be used to present new arguments or evidence that could have been raised earlier. And again, she brought forward no evidence that shows what she knew at the time of making the statements. If a movement can demonstrate the discovery of new evidence not previously available, the movement must show that the new facts are of a strongly convincing nature to induce the court to reverse its prior decision. Put differently, to prevail on a motion for reconsideration because of newly discovered evidence, the movement must show the evidence, one, existed at the time of the trial or proceeding at which the ruling now protested was entered. Two, could not have been discovered through due diligence. And three, was of such magnitude that production of it earlier would have likely changed the disposition of the case. And even with everything else, what the TikToker is talking about doesn't change the case. Argument: the court should deny the motion because the evidence she cites does not change the court's holding that the TikToker defamed the professor, and she could have previously obtained the evidence she now cites. The evidence she cites does not alter the court's decision to grant partial summary judgment. When the court granted Professor Schofield's partial motion for summary judgment, it, quote, concluded that defendant defamed plaintiff when she publicly accused her of having an inappropriate same-sex affair with a student and then engineered the student's murder along with 3 other students to cover up the relationship because those accusations had no basis in fact. And again, for those of you that are new to this case, asking why it is defined as an inappropriate relationship, because she is a professor and that is a student, and that goes to workplace propriety, that relationship would not be appropriate. So there are 2 defamatory statements here. One defamatory statement that goes to the professor's ability to do her job as a professional, and then the other statement accusing her of a murder. So those 2 different statements are both defamation per se, and the court has gone through both of them. The court reached the conclusion by applying Rule 56 standard. It first found that Professor Schofield satisfied her burden of showing she was entitled to summary judgment by presenting affirmative evidence, quote, demonstrating that she had nothing to do with any of the students or their murders. This shifted the burden to defendant to dispute the claim by setting forth facts showing that there is a genuine issue for trial relating to whether her statements about plaintiff are true. The court concluded that TikToker did not satisfy her burden, thus summary judgment was appropriate. Yes. Giselle in the chat said, is she an actual professor? Yes, she is a history professor and the chair of the history department at the university. Beavis asked, was the professor actually in a relationship with one of the victims? No, the professor didn't know any of the victims. So, no. The current motion does nothing to disrupt the court's prior reasoning. To start, the TikToker failed to establish how her cites to URL addresses in Kohberger's prosecution constitute admissible evidence. Your Honor, that's not evidence. That's not evidence. Lindsay D said universities allow professor-student relationships. The University of Idaho has quite a lot of rules about it. We went through them in other motions. It is at this university, per the rules that had been provided in the briefings, not permitted. So it went directly to the defamatory statement. So some universities may, this university does not, if that helps. But the rules of the university and the guidelines and like all of the employee manuals and stuff, those were all brought forward in the motion for summary judgment, which I covered ages ago. It feels like, because this has been going on for multiple years now. Okay, so the motions in the other case are not admissible evidence, facts. Although the filings in Kohberger's case may be judicially noticed, the evidence cited in the filings cannot. Right. The court can say the fact that a motion was filed, but what's underlying that motion doesn't come in. And it's, again, the lawyer here gets a lot of credit from me. Lindsay D, of course. Lindsay D said, that is helpful. Thanks for clarifying. Of course. We've covered this a lot. So as everybody jumps in new on this case, it's like, wait, what is happening? I know. The lawyer in this case is in a really difficult position because lawyers are very well trained to perceive what the other side is going to do. Normally, that perception is filtered through the lens of what will another lawyer do. It is harder to jump the rails and be like, what is someone going to argue that doesn't adhere to the boundaries of this game? It's like trying to perceive of what the other team is going to do, and you're playing two different sports. Like, I don't know, pick something that is as divergent as you can get. You know, somebody thinks they're there for a swim meet. The other team thinks they're there for water polo. You just end up with people getting pummeled and the swimmers being like, wait, I thought we were just doing a flip turn. What's happening? So this is just wild. Oh, you guys, it's been a minute since we've had trolling in the chat. Hold on. I never get to ban anybody. There we go. That was fun. Yay. Wait, I don't think I did it right. Mods, will you just make sure I actually banned? Why are we getting trolled? That's hilarious. Like, of the same type of trolling. It's been a minute. Hold on. Mods, let me do it. Wait, I want to do it. I want to ban hammer it. Wait. Can I do it? I think it already happened. Thanks, mods. That's the strangest level of trolling. They're all the same message. Hold on. I got this one too. Whoomp. There it is. Hold on. Multiple ban hammers. That's hilarious. Like 4 or 5 of the same message. Don't y'all come in here trying to start shit between me and lawyer you know. First of all, not going to happen. Second of all, man's off celebrating NC2A things, I think. That's funny. Thanks, mods, for letting me do it. It was fun. Thank you, mods. It was great. Oh, goodness. That's hilarious. So, don't worry if y'all missed it. It's fine. I'm not going to highlight the wild trolling, but people coming in trying to start shit with lawyer you know is going to be a miss. Trying to start shit over politics is going to be a miss. Trying to say shit that I know is fundamentally not true about what Peter thinks about me is hysterical. And also, I don't know, like, what the what? That's hilarious. I hope y'all had fun getting banned. I had fun, so thank you for that. But what you're not going to do is start it. Wait, is it the wrong Florida? I just went, oh, Florida, Peter must be happy. Emily, wrong Florida. Sorry. All right. Probably not. Fair enough. The Cozy Treehouse at EDB. I love your ability to laugh and roll it off. Look, man, it's the internet. You have to let stupid shit go. You have to. That's fair. Florida's not all the same. Wrong Florida. My bad. Sorry. Damn it. Peter's chat. Emily said you were celebrating basketball wins. Wrong sports ball. Let's get back to TikTok psychics. It's just so weird when people try to start shit between content creators that there's no shit to start. I didn't mean to troll Peter. I was just like, oh, Florida. I didn't even, there are different Floridas. The blasphemy. Accusing an FSU grad of rooting for UF. My bad. I was just like, oh, Florida. Wrong one. Wrong sports ball. I don't know. Is he happy about golf? Just pretend I was talking about golf. We'll go back to that. Sports ball. Let's see. Gouliard's current motions, the professor says. I didn't mean to troll. Genuinely confused. Valkyrie's like, Emily, that's like saying a UCLA fan's cheering for USC. It's fair enough. It's fair enough. It's fair enough. If, golf. Happy about golf or something. The TikToker's current motion does nothing to disrupt the court's prior reasoning. To start, she has failed to establish how her sites to URLs are evidence. Your Honor, it's not evidence. Oh, what was I saying? Before the randomness, I was saying that the lawyer in this situation has a really difficult time because she's not arguing against legal reasoning. She is trying to argue against arguments that don't hold water. And that's a difficult thing to do. Like the fact that these motions aren't just like, Your Honor, she didn't do her assignment, so how can I do mine? Like, we're supposed to be talking about Haiti and she's talking about some garden party because you know the TikTok psychic would just be like, it's his 50th birthday. So you can see the difficulty for the lawyer trying to apply legal reasoning to an argument that is not founded in legal reasoning. It's difficult. The professor's lawyers go on to say, nor can the accuracy of evidence cited in the filings be unquestioned, as Kohberger and the state are litigating the admissibility of evidence in that proceeding. That's exactly what motions in limine are. What evidence comes in, what evidence stays out. They say that the TikToker's failure to establish admissibility in this proceeding is alone enough to preclude the relief of the request. Quote, only admissible evidence may be considered. No ipsy dixit. But even if the evidence cited were admissible, here's our arguendo. Even if we jumped the shark into the alternate reality that we are being asked to assume is true, it still doesn't change anything. The evidence that the TikToker supposedly presents, supposedly is my word, fits into three buckets. One, evidence related to the white Hyundai Elantra purportedly seen near the crime scene. Two, evidence related to the victims and their roommates' activities around the time of the murders and the subsequent investigation. And three, physical evidence that purportedly exculpates Bryan Kohberger. None of that evidence even remotely suggests Professor Schofield had an affair with a student or orchestrated the murders. Starting with the evidence about the white Hyundai Elantra, Gouliard's argument is premised on a misrepresentation to the court. She says that the professor, quote, admitted to having access to a white Hyundai Elantra during the night of the quadruple murder of the four students. That representation is false. Shock me. Gouliard solely cites a request for admission that Professor Schofield directed to Gouliard. The request for admission asked... Oh, that is not the same thing at all. Here's what happened. The TikToker is citing a request for admission that was propounded to the TikToker. So the professor asked the TikToker the following question, because request for admission is part of what goes back and forth in discovery. Admit that your name is this. Admit that you operated this TikTok account. Admit that XYZ. The request for admission asked TikToker to admit she never stated that the professor had access to a white Hyundai Elantra until after law enforcement publicly stated they were looking for information about the vehicle. So admit that you didn't bring this up until after law enforcement made this public. That's wild. To flip that back into a, well, you admitted it, is the height of circular argument. She asked me to admit that I didn't say this till then. Obviously, that means that she had access to that. Directing a request for admission to TikToker is not an admission by the professor of anything. Facts. Asking the question is not an admission. If any of you recognize the patterns that TikToker is engaging in and have to engage with someone with those patterns, gray rock is about all you can do. It's about all you can do is just be like, no. Mm-mm. 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 They go on to say that the TikToker's response to that discovery request proves she revised her false story about Schofield as law enforcement released information. I am shocked. As law enforcement made more things public, she changed what she was saying to make it seem like she was right all along. Shocking. Gouliard's claim to any so-called claircognizance, I'm waiting for this lawyer to be like, means she should just see what's coming and acquiesce. This lawyer has had more patience than I would have had, which is why I did not do civil law. I did not have the patience for civil law at all. TikToker learned about the white Elantra the same time as everybody else. She had no special insight about the vehicle's purported involvement, nor does she have any evidence linking the professor to a white Elantra. Moving next to evidence about the victims and their roommates' conduct and the subsequent investigation, TikToker's presentation of evidence is irrelevant. She suggests it is somehow pertinent that the surviving roommates were afraid the night of the murders and decided to take refuge together, and that a victim's dog was around but separate from the victims, that one of the victims broke up with her boyfriends before the murders, and that the victims were killed in different rooms, and that law enforcement arrested a suspect. It's hard to fathom what TikToker views as surprising about two college girls being afraid when their roommates were murdered and they saw a man wearing a black mask, a dog being in a house, a college girl breaking up with her boyfriend, and people being in their own bedrooms at night, or law enforcement arresting a suspect after a quadruple murder. These purported facts do nothing to suggest that TikToker had any special mystical powers, and in any event, they do nothing to prove or even suggest that the professor had an affair with a victim or orchestrated the murders. Ending with evidence that Gouliard argues exculpates Kohberger, Gouliard's presentation of evidence is irrelevant. She asserts that a victim had 3 sets of DNA under her fingernails, which will come up more in trial. By the way, none of that DNA was the professor's. They argue that there was blood from multiple males found at the crime scene. One of the victims is male, and that a knife sheath was planted at the crime scene. The professor does not know the veracity of any of these assertions or whether they provide admissible exculpatory evidence in the state's case against Kohberger, Regardless, this case is not about whether Kohberger committed the murders. As the court explained last time to TikToker, when she moved for reconsideration, although some issues in this case may have touched upon a matter of criminal concern in parallel criminal proceedings in state court, the court never endeavored to apply the elements of the crime of murder to adjudicate plaintiff innocent and Kohberger guilty. Simply put, even if some physical evidence may tend to exculpate Kohberger, that evidence does not then somehow suggest the professor had an affair or orchestrated the murders, which are the defamatory statements here. Gouliard failed to prove that the court erred in granting partial summary judgment in favor of the professor. The court should thus deny the motion. Gouliard improperly relies on evidence that could have been obtained earlier, and she goes through the fact that the defendant in this case did no discovery. We're not going to go through the fact that she did no discovery, or that this has been referenced in the media. Let's see. And if she was claircognizant, shouldn't you have known that the evidence existed and asked for it in discovery? I'm just saying. G-Mommy said, I think we're septupling down at this point. Yep. But shouldn't she have known where to ask for the evidence? Why is she having to wait for it to come out in publicly filed documents? I have a question. The court should proceed with a trial on the damages. Portions of TikToker's motion suggest that she thinks this case should not proceed until the conclusion of the criminal trial, but it is unclear whether the TikToker is affirmatively asking the court to delay trial. To the extent her motion does request a delay, like if this is what she's arguing, then the court should deny the request. Rule 60B allows the court to revisit a prior judgment or order. It is not a vehicle for staying a case or modifying a case schedule. Even if the request were procedurally proper, the court should not further delay trial. The professor filed her complaint over 2 years ago, and they barely went through discovery, and they got to summary judgment, and we're still over 2 years in. It's approaching a year since the court granted the partial summary judgment motion. We're a year out from liability. At every turn, TikToker has obstructed forward progress, failing to file timely answers, failing to respond to discovery, inserting frivolous counterclaims, filing baseless motions challenging the court's reasoning and authority. The TikToker has no intention of changing her behavior or taking responsibility for her actions. The only way the professor can obtain justice is to complete this litigation, and she deserves the right to do so. TikToker has done nothing to suggest that Kohberger's trial or anything else will ever change the reality that she disrespected the 4 students who were murdered and defamed the professor to gain attention and notoriety on the internet. If you have followed this case from the beginning, at one point this was referred to as a clout circus in a footnote, but the thing that the TikToker takes the most objection to is being told that her behavior is to gain attention on the internet. And so it really is the lawyer saying that, look, this is where we're at. And this lawyer has gone quite a long way to not be snarky in any of the motions, more restraint than I think I could have. And this one line is kind of a dual purposed sentence. And I applaud the attorney for taking a moment to just be like just the one, but really a fairly restrained motion, because I am sure the initial reaction to this is, you've got to be fucking kidding me that we are doing this again. Though the attorney is probably prepared for the just unending, merry-go-round of litigation in this case. And it is so frustrating. I feel for this I feel for this plaintiff. I think that she never should have had to bring this case. And I am frustrated for her that we are this many years in and still going through the court process, because there will be no reasoning with this defendant who is sextupled down on, but I could be right. So prove it. It's incredibly frustrating. So I don't normally say to the law nerds, just ignore people. I say to you guys, you know what, make your decisions, do what you want. If there was any case that I have strong opinions about, this one is right at the top there. And if you come across the this individual's platforms or content, my only suggestion, if you feel strongly about this case, would be to ignore it, because sending hate to someone, sending a "what the fuck are you doing" in this case, is still attention. So though the professor in this case can't just let this go and has to finish up with the court process, the rest of us can ignore this person. And that is really the void of attention is, I think, the best we can do as the internet to ignore. No comments, no statements, no acknowledgements, just absolute vacuum. It's why I do not put this individual's face in thumbnails. I do not talk about them by name. I do not want anyone to go looking for their content to give it views and see what they said. All we can do is let it, as the chat said earlier, fade away. Just the attention is sought, and we can deny that attention. And that is, I think, the best that we can do. Laura in the chat said, do not feed the clout goblin. Yep. So again, lack of attention is the best that we can do here. So thank you all, chat. Again, if there's something you don't like on the internet, pulling your attention away, every platform on the internet is based on attention. Some platforms endeavor to figure out positive, negative attention. Some platforms do not give a fuck. They're like engagement. It doesn't matter if you are engaging with something because you hate it, because it makes you mad, because it's damaging to you and now you're down the rabbit hole, or if it is uplifting and you feel better. Most platforms do not care. It is the attention and the eyeballs that the platforms correct for. So any flood of attention, the platforms will go, oh, there's attention to this. Other people might want to pay attention to this. It does not matter what that attention is based off of, because the platforms do not care. Do not waste your energy, and anger takes a lot of energy. Do not waste your energy on this. And sometimes it feels good to just, be like, we're unbothered. I'm bothered by this case, but I'm not going to give that person any attention. No attention. None. We're going to keep talking about this professor who is stuck in this boot loop of hell, trying to clear their name when they were accused of something horrific. Don't do that. This is horrible behavior. Don't do this. Also, to everyone who uses, oracle cards and tarot cards and the entire rest of the community that creates content in that way on the internet, they don't want her doing this either. It's just stop it. So all of us, we have the power to ignore. So mute. I feel for this professor. All right, let's move on to the rest of the Kohberger cases with the Kohberger prosecution. I've said what I have to say about it. It just makes me so, this one makes me so frustrated, but I talked about it earlier, why it's important. I think it's important to cover it. So we're there. All right. The key, where is it? Emily, where are the rest of your notes? You have too many notes. I have so many notes. The The motions in limine that I am looking at, there are numerous. I thought we would start with the text messages and then go from there. For all of you who are like, there are great tarot readers out there, there are. But again, personal use, man. Personal use. Entertainment. Not to accuse people of murder. Like that's not what it's here for. So, however, even if the TikToker had said this is for entertainment purposes only, I think this person committed this murder, it's not going to save a defamation case. It's not, and we need to get back to that. That's going on in another content creator defamation case. But just saying, this is my opinion. It's my opinion that this person murdered that person. That still won't save you. So, okay. The ones I am looking at are regarding Alibi, text messages. We need to talk about AT&T. We need to talk about Amazon. We need to talk about Bushy Eyebrows. We need to talk about the vehicle. So we're going to have to zoom. SL said, what about the word allegedly? It does not save every circumstance. So if you said, there's a difference between saying, this court document alleges this person does that, is different than saying, well, I mean, this person did XYZ allegedly. It's not going, just saying allegedly is not going to cover it unless you are covering other things. So there's a balance there. You can't just tack an allegedly on to something and have it be a cure-all. What, if anything, is not a cure-all? Allegedly is not a cure-all. If you're pulling up to other source material, this source material is saying that this person's alleged to do that. That's different. Because then it goes back to whoever originally said it. It's not coming from you. But if you're the one originally saying the thing and making an accusation and saying, well, I mean, it's all alleged, it's not going to help if the statement is defamatory. So let's do a quick swoop-a-doop and go from there. Getting into the motions in limine in the Bryan Kohberger prosecution in Idaho, there are a substantial number of motions, and they are going to be argued over the next 2 days, Wednesday and Thursday, April 9th and 10th. Those motions are going to shape what evidence comes in, stays out, and we have watched motions in limine in pending trials. These are quite a substantial bit ahead of jury instruction or jury selection, which is supposed to start in August. The court is giving itself a lot of room for continued motions and for the last minute things that come up. But this case has also been pending for quite a while. So the shape of the evidence should be known by the parties, I think, as we get into some of these motions. And I have seen continued motions for discovery being filed. We're not done with the full shape of the evidence in this case. We know that there are terabytes and terabytes and terabytes and terabytes of data in this case. And so I suspect that we will have more motions popping up on the docket in June and July as well. But the court, it seems, really wants these matters settled well before this case starts picking a jury, and they have time to do it. I think pushing the deadline earlier allows both sides to find, the things that are missing. Once you start going through it, you're like, oh, well, that's what's missing. Not the Commonwealth. Emily, we're not in Massachusetts. The state has just added an additional prosecutor. So we will see if that individual is in court tomorrow when we tune into these motions. If you don't have the Law Alert app, we built it free for you so you can stay in the loop, particularly with live court and with the quick updates or with the cases that you want. Some of you are like, I am fatigued on the Reed case. I want to pop in when you're covering other things. The Law Alert app will let you know what we're covering and when, and we'll let you know when I'm streaming at not the normal time, which is 11 a.m.-ish Central. So tomorrow it'll probably be an hour earlier, depending on when when the court actually starts, but it looks like it should be starting around 9 Mountain. So we should be starting around 10 Central. That's the goal. So let's get into these. We will do a pickle cleanse at the end. I see all of you asking for a pickle cleanse at the end. This is not easier. We're not getting into easier stuff, right? We're not getting into easier stuff. So Maddie asked in the chat, is this the judge that runs the courtroom like an appellate court? Yes. Judge H is very much appellate-y. Is this Santa prosecutor? Yes, it is. All right. Let's start. Where do we want to start? Let's start with the alibi and then the bushy eyebrows. I think those will be a little bit lighter. The text messages, I'm just going to put this out there. The text messages are hard for me. I do not like covering cases with kids. I am not covering the Lori Vallow stuff. I have not covered it. I know she's representing herself. But this case, even though these are young adults, as you know, anyone who has teens, even as they are becoming young adults, for me, this case, and I don't mean it in any way disrespectful to these young adults, but these are college kids. And so from a parental standpoint, this case, there are parts of this case that are really hard, that are still relating to, you know, you send your kids off to college and you're like, woohoo, they're turning into adults. It's hard. So we're going to leave the, we're going to leave the text messages to the end. They're really hard, and they're hard. You don't want anyone to feel the way that they are feeling. And this case is deeply, deeply sad. So I'm going to cover the other stuff first, and I'll leave the text messages to the end. I imagine I'm going to feel this way no matter what age my own kids are. And so it's kind of like when you're younger than me, I feel protective. It's where I'm at. This case is, there are parts of this case that we've been able to step back at and look at the evidence in this case in kind of a more analytical and neutral, almost detached way. But there are parts of this case, and when it goes to trial, that are going to be incredibly difficult and sad and not detached. So I'm going to leave the texts to the end because they're sad, and you can feel it. And that's going to be true for me no matter what age a victim is, but it's hard because there are also things with the surviving roommates that raise big question marks. So we'll get to those later. We're going to go with the more detached things first. And then we'll get into the stuff with the surviving roommates later. And let's see. We were going to start with Alibi. I said I was going to start with Alibi. I think we will just start with that. So let me throw this up on the screen and start with the motions in limine regarding Alibi. And then we will timestamp all of these by motion down below. All right. Let me embiggen this a little bit and go to the Alibi motion. This is the states. If I interchange state and commonwealth, I apologize as we shift between different jurisdictions. It's tough. Kookie in the chat said, the more I learn about this case, the more questions I have. Yep. And there are going to be questions that we are going to ask because at the end of the day, they're going to come up in trial. And will come up at trial. That is the point of a trial. It is an adversarial process. And even though the surviving roommates aren't on trial, the things that they did, said, acted, behaved, is going to be questioned at trial, and questioned, I think, pretty vigorously by the defense. So we have the balance of having space for empathy and also asking questions as a criminal prosecution goes along. This is from the state regarding the alibi. The state is asking the court in limine for an order prohibiting defendant from presenting evidence, whether direct or cross-examination, in support of any claimed alibi other than from the defendant himself. Look, if you've got an alibi, fine. You need to testify to it. By way of background, the state refers the court to the following: the state's May 23rd, 2023 request for discovery disclosure alibi demand, the state's July 22nd, 2023 motion to compel notice of defense alibi or bar certain evidence, the state's August 2nd, 2023 objection to the state's motion to compel, motive or defensive alibi, alternatively to bar certain evidence, the attached pretrial transcript of the August 18th, 2023 court hearing relating to alibi, when then presiding judge observed that the defendant's proffered, quote, so-called alibi is not really an alibi, and he will address the issue of alibi disclosure in a subsequent scheduling order. The August 22nd, 2023 nunc pro tunc to August 18th scheduling order. Nunc pro tunc means just, we don't need to get into it, but that order was moved to an August 18th scheduling order, which was moved to an August 22nd scheduling order, which in paragraph 7, page 2, addresses the deadline for defense to comply with its statutory obligations for alibi disclosure. The scheduling order was subsequently vacated when the defendant waived speedy trial. The state's December 21st, 2023 motion for scheduling order, the February 23rd, 2024 scheduling and setting deadlines and hearing, which sets the alibi compliance deadline as April 17th, 2024. The defendant's April 17th, 2024 notice of defendant's supplemental response to state's alibi demand. The state's April 26th response to notice of defendant's supplemental response for alibi demand. Former presiding judge's June 27th scheduling order and subsequent April 17th alibi disclosure deadline. That is all what happened. Ghost Owl said nunc pro tunc is my next D&D character name. It's fantastic. It is, my husband's just out there doing yard work. It has been approximately 20 months since the state first made its request for discovery disclosure alibi demand. As the court file reflects, the defendant has failed to comply with the requirements of Idaho Code 19-519 and ICR 12.1. The defendant has yet to specify the specific place or places at which the defendant claims to have been at the time of the alleged offense and the name and addresses of witnesses upon whom he intends to rely to establish such an alibi. A alibi, under all of the sections in Idaho that have been cited, is I was not at that location because I was at this location, and these are the people that will see me there. So it is I was here and who I was with. That is the type of alibi evidence they are asking for. The defense saying the defendant was out stargazing is not an alibi under this section. It does not fall under that. That might be the defendant coming in and saying, hey, I'm testifying and I'm saying I wasn't there. I'm saying I was elsewhere. But that is not an alibi that can be established by other evidence. That is the defendant having to testify and say, I wasn't there because I was out stargazing. And this shows you that. Different than establishing evidence that the evidence in the case doesn't point to him being there. That's also not an alibi. That is doing your defense work. An alibi is limited in what can be proven. So again, specific places, locations, witnesses. I was at the movies. Here's the movie theater. Here's the ticket. Here's the people that were at the movie theater. Those types of things. Terry, can it be an alibi if you were by yourself? It's harder, but you could say I was at this location and these things prove I was at this other location. Even saying, I was at home this entire night and these things prove I was at home. That can count, but it's not what they're asking for. it would give an address because, again, if you are at home, most of our homes would indicate that we're home in a variety of ways. Either your digital devices being connected to your home Wi-Fi. There are ways that you can establish that you were at your home. If you were elsewhere, there's ways you can establish that with receipts, screenshots, license plate readers, but the machines do lie. Now, if you have a purely analog home and you're completely off the grid, that's going to get a little bit more difficult. So, let's continue on. They say the defendant has yet to specify the specific place or places at which the defendant claims to have been at the time of the alleged offense and the name and addresses of witnesses upon whom he intends to rely to establish such alibi. Those are the things that the state is asking to be disclosed. Those two things. The defendant's proffered April 17th, 2024 notice of defendant supplemental response to alibi demand does not comply with the requirements. Consequently, the defendant should be prohibited from presenting any evidence, whether direct or cross-examination, in support of any claimed alibi. Even where defendant attempted to comply at this late point in time, even were the defendant to attempt to comply at this late point in time, the state is irrevocably prejudiced. So, Your Honor, they can't come up with it now. And then they cite the case law to say even if they want to turn over more information, now is not the time. They're saying the court should issue an order prohibiting defendant from presenting any evidence, whether direct or cross-examination, in support of any claimed alibi other than from the defendant. And then they attached their exhibits. We watched those hearings. So we aren't going to go through that. Let's go to the defense's response regarding the alibi. And putting the response up on the board here and pulling that up this way. Defendant's objection to the state's motion in limine regarding alibi. Comes now defendant by and through his attorneys of record. This is single spaced. It is just harder to read. The state provided the court a list of pleadings to take notice of in support of this motion. However, the state failed to provide the court with the full scope of the pleadings. Kohberger filed a response. That's a fair point. Kohberger filed a response to the state's request for discovery disclosure of an alibi demand on June 9th and contemporaneously filed a motion for an exception or in the alternative to extend time for compliance. And that's fair. They're saying that the response by the defense is non-compliant. And they did say that, and the defense is like, well, we responded. You just didn't like what we had to say. So that's not that we didn't respond. Let's see. The notice stated that at the time alleged by the state, let me read this better. Kohberger filed his notice of alibi on July 24th, 2023. This notice stated that at the time alleged by the state, he was not inside King Road. He was driving his vehicle and not in Moscow. But that does not give an address, location, or witnesses. So they're saying that that is not compliant. The state filed a motion to compel on July 27th, and a hearing was held on August 18th. The state provided a partial transcript of the hearing. Subsequently, speedy trial was waived and the scheduling order vacated. The code governs notice of alibi and requires specific names and places to verify where a defendant was at the time of the crime. Kohberger advised the state he intended to offer expert testimony through Sy-Ray, I think that's how you would pronounce that, S-Y-R-A-Y, as a partial corroboration that he was driving south and west of Moscow. I think the defense has an argument here that this is not the type of alibi that can be blocked, because if the state is bringing in experts to say, this is how we know he was there, then the defense is allowed to bring in rebuttal witnesses to say, and this is what indicates that they're incorrect. So I think that this might fall outside of alibi and fall more into rebutting the state's case. So I think that's where this will fall. I don't think the court will limit the defense on how they can rebut the state's evidence. They might not be allowed to say that this is an alibi. So we'll see. Angie said, I thought Hippler said Cy couldn't testify. I haven't seen that. The only motion I saw regarding testimony was whether live testimony was needed at the motion hearings. And the court said, I don't need live testimony at the motion hearings. I have affidavits and filings. So that's not testifying at trial. No decisions have been made about who can testify at trial. The only thing I've seen is regarding arguments during the motions in limine. And you don't normally have testimony during motions in limine, especially if there are affidavits. The court's like, I have the motions. I don't need it. So that's all I've seen. Let's see. They go on to say that the expert testimony involves cell site location information, CSLI, and Kohberger further advised the state of his intention to cross-examine any state expert in the field, which again is allowed. You're allowed to vigorously cross-examine the witnesses. After that disclosure, the court heard Kohberger's fourth motion to compel, wherein, among other things, Kohberger sought further records related to the CSLI. Kohberger called Ray to testify at this hearing, and the state declined cross-examination. So during the motion to compel hearing, and a lot of those have been sealed, it seemed that Ray was called to testify. The state provided records necessary to CSLI in various batches of discovery. The records consisted of cell detail records from AT&T cell towers and drive test data. We're going to talk about AT&T records more in a bit. The state provided its cast draft report and later a final report. However, no analysis has been provided. The state did not produce a timing advance report for Mr. Kohberger's cell phone. Footnote 1. See also motion in limine to exclude experts and objection to state's motion in limine to exclude reference of timing advance records. We're going to get into that in a different motion. They say partial corroboration does not cover the time alleged in the state's charging documents or in any affidavit in support of searching or seizing Kohberger's person or property. Partial corroboration relates to where Kohberger was during the early morning hours of November 13th. The state cites to State versus Jerez, Williams versus Florida, to suggest that Mr. Kohberger is hiding a witness that will prejudice the state. That is not the case. Kohberger has stated exactly how he will partially corroborate where he was. He will use information contained in the discovery supplied by the state and will present an expert. And I think a lot of this is going to feel like splitting hairs when we get down to it, because if the state is providing evidence that they say points to Kohberger being at the residence, the defense is allowed to bring in experts to rebut those experts. Is that technically an alibi saying, well, he was at this address? Not technically. It goes to, well, the state didn't prove he was at this address because here's other options. Do I think that hair splitting will matter when we get to the end of closing arguments? No. Do I think that the court will keep that testimony out and keep an expert out at trial on that topic? No, I don't. Because the defense is allowed to rebut the state's evidence. Let's pull up the reply on that real quick and move on to other matters. The defendant's objection to the state's motion offers nothing new or substantively different. Okay. In fact, defendant appears to now acknowledge that he does not have any witnesses potentially other than himself to establish where the defendant was at the time of the alleged offense. They're allowed to argue that the state didn't prove he was there at the time of the offense. Okay. They go on to say, at best, the witness mentioned by defendant Cy can only testify generally to his opinion about where the defendant was during the early morning of November 13th. I mean, is the state's evidence different? Hold on. I'm out of water. So this, again, to me, this is rebuttal, and I don't think the court's going to say, no, you can't present this expert to rebut the state's information. So based on the evidence, we know for a fact that cellular analysis cannot show where the defendant was, quote, at the time of the alleged offense. Can it show where he was before and after? Because that would be relevant. As required by the applicable statute. Again, this is hair splitting. Okay. He might not be allowed to call it an alibi. Fine. They're not going to block the defense from bringing in a tech expert to rebut the state. I'm going to stop repeating myself on that. All right. Let's move on to the next motion in limine. It seems that since we are talking about alibi and tech experts, it makes sense that next we go to the AT&T motions. Chat, what do you think? Should we just talk about the tech? Do we just stay in all of the tech and just get the tech stuff done together? Or do we talk about the car? Tech first, then car? I think so too. Tech first, then car. Let's do that. All of you are like, do it. Not just asked, do I think Bryan Kohberger will testify? It's too early for me to give you a thought on that. I want to see how the evidence comes in. So I don't know enough, and I don't think there's enough known about the case to really give a good thought on that. In general, most defendants in cases like this do not testify because it does not help. So that is there would have to be a lot to change that general truth. Let's look at the state's motion in limine regarding the AT&T timing advanced records. That's the tech that we're going to next. So everybody get ready to get tech nerdy and see what we know, what we don't know, and what we're going to learn. A lot of you are asking me if I'm going to go over the defense affidavit. Yes, it's part of these motions in limine. So we are moving on to the motions in limine regarding AT&T data. Let's do that. And I accidentally unshared my screen. That's super helpful of me. Good job, Em. That streaming is dynamic. All right, let's embiggen this a bit so we can actually read it without needing a new prescription. This is from February 24th. This is the state's motion in limine regarding the AT&T timing advanced records. All right. The state brings this motion based on defense counsel's repeated references to the alleged existence. You can see where the fight is. The alleged existence of AT&T timing advance records related to defendant's cell phone. And then they cite where the defense has brought those up. The state has been advised and will offer documentation or testimony that AT&T records are produced by their Global Legal Demand Center. This is going to come up a lot. AT&T GLDC did not begin producing timing advance records until May 2023. For those of you that have already read where these motions are going, no spoilers. We're going to cover the state and defense arguments on this. Just let it happen organically. I know sometimes it's hard to wait. We got to these late because we've been covering so much court and other cases. All records for defendant's phone were obtained from GLDC in December 2022. The state intends to supplement this motion with additional information from, oh boy, from who?
The FBI!
Mm-hmm.
The FBI!
and or AT&T prior to hearing on this motion on April 9th. I have not seen a supplemental, but there's a ton of shit in this case that's under seal. So I don't think we're going to. Any statements or inferences by defense counsel or their witnesses that there is additional evidence that could have been provided or was not provided is a mischaracterization and should not be allowed. That's what the defense is, or that's what the common third time's the charm. That's what the state is arguing. That any references to additional records is a mischaracterization. That's the entirety of their motion. Let's take a look at the defense. We have a defense opposition, a state reply, and then an additional affidavit that came in later from the defense. Those are the three things that we are going to go look at next. But keep the state's argument in mind. Let's go to the defense opposition on this. And then let's make this bigger. This is the objection to the state's MIL regarding the AT&T timing advance records. The state's motion seeks to prevent Kohberger from confronting through a full and fair cross-examination a portion of this case. The state seeks Kohberger's silence on records produced by AT&T, timing advance records. The state's motion informs the court that TA records were not produced by AT&T GLDC until May of 2023. Mr. Kohberger agrees with that claim. However, that is only partial information. The state is misleading the court in its motion by what it leaves out. What the state is not saying, and that was my bold voice. It's in bold. What the state was not saying is that the TA records existed at AT&T in November and December 2022. Do they still exist? Do they still exist? The state has to know this. The state has to know this to be true because in April of 2024, the state produced the actual records from AT&T for cell towers and individual TA records for 2 of the 4 deceased and 1 for a person who has been a person of interest at the beginning of the investigation, interesting, as well as over 3,800 people on the cell tower. Your Honor, the state said they don't exist, but then they provided them. These records were from November of 2022 and were produced in discovery to Kohberger in 2024. It is accurate that AT&T Global Legal Demand Center did not produce TA reports to law enforcement in 2022. So technically true. This branch of AT&T does not produce those types of records at that time period. The timing advance reports from AT&T GLDC were not available to state and local law enforcement until June of 2023. However, the existence of these reports in this case is direct evidence that these records could be and were provided to law enforcement by AT&T prior to production through GLDC. Your Honor, it's true that this center of responding to law enforcement did not produce these records, but that does not mean the records did not exist. The records existed and could be provided by AT&T through other means. It seems to be what they're saying. They go on to say, as such, Kohberger's TA report from 2022 would not have been provided through AT&T's GLDC. They would come from somewhere else. Footnote 1. AT&T GLDC began storing the data to produce the TA reports in May of 2023, but did not provide the actual TA reports to state and local law enforcement until June of 2023. Okay, so that's literally true, but what are we missing? AT&T had TA reports prior to their availability through GLDC. The state attempting to say the reports were not available until GLDC produced them is nothing more than asking the court for permission to hide from the state's failure to disclose Kohberger's AT&T TA report. I don't see how this isn't fair grounds for cross-examination. I don't see how this isn't fair grounds for... Am I dumb? Like, I don't see how this isn't fair grounds for... This is exactly the point of cross-examination. To ask the people, hey, you grabbed this record. Yes. Was this type of record provided by this place? No, that place didn't provide this type of record. Okay. Who provides that type of record? Did they provide it? Did you ask for it? AT&T has custodians of records that come in and testify, and I imagine will come in and testify here. This is proper grounds for cross-examination to ask, could you have provided these records? Yes or no? Why or why not? This is grounds for cross. You can't just be like, don't ask about the investigation. I'm confused. Let's keep going. The state, it seems like the state is really throwing a Hail Mary on this, but I'm curious to see what the state says. Depending on how far back the report goes, it will contain exculpatory evidence that will partially corroborate Kohberger's alibi. I don't think it's an alibi, technically, but again, I'm not going to split hairs over the alibi. I think that is also proper grounds for rebuttal evidence. The state has to prove he was at the place. If they have rebuttal to show that he wasn't at the place, then that's exculpatory. Call it an alibi or not, that is exculpatory. I should say that can be exculpatory. They say Kohberger will provide evidence, testimony, and argument in support of his claim that the state misrepresents the availability of the TA records. I'm real interested to hear this get argued tomorrow. Let's keep going. The defense says that Kohberger's TA records are different than other records provided in discovery. The records are location data that are accurate in determining the location of a cell phone. TA is a term used in the cellular network industry relating to a measurement of time. It measures the time it takes for a radio frequency signal to travel between a mobile device and a base station in a cellular network. TA is required in cellular networks to assign a time slot to a mobile device, allowing it to transmit data so that it doesn't interfere with other devices. Given the signal, I feel like we're back at My Cousin Vinny what the timing stroke of the engine is or whatever. I know little about cards. Given the signal is traveling at a known speed. Oh God, that looks like math. Ugh. The speed of light / 299,792 kilometers per second, kilometers per second. It is possible to use timing information to determine the distance of a mobile device from a base station. Fair, you just need an expert. Chronic Shock's Art Journal said, wait, was there a hearing today? No, the hearing's tomorrow. Emily Ippolito said, no, that's physics, run away. Run away, run away, run away. Emily, is your understanding of number things so rudimentary that you said math and everybody in the chat went physics? Yes. Just look, if somebody can get Doctor Who to explain it to me, I'll understand. Can you put this in a Doctor Who episode? I need sci-fi to explain it to me. Pick a sci-fi and tell me what episode to watch, and then I'll understand better. But it is, again, a lot of information can come off of cell sites. And how densely packed or sparse cell sites are in this area is going to be relevant to this case, particularly if they're trying to track the movement of an individual's phone. They say this is known. It's possible to use the timing information to determine the distance of a mobile device from the base station. These measurements can be very accurate. Well, we would need to know what impedes those. I imagine weather would play a factor, etc. When a mobile device is using multiple cell sites, it's possible to utilize no. That doesn't say triangulation. I don't know what that word is. Is that a typo? What are we trying to say? Hold on. I can't read this. What are we trying to say? Trilateralation? a method of determining the position by using distances from at least 3 known points. How is that not different? How is that different than triangulation? What is the difference? Whatever. Triliteration. Thank you. Triliteration. Is it same? The use of distance or ranges for determining an unknown position coordinates at the point of interest. All right, fair. I'm going, well, oh, the AI on Google would like me to know what's the difference between trilateralation, something, and triangulation. In trilateralation, I don't know how accurate this is. I'm reading Google, folks. I've Googled so you don't have to. We estimate the position of a mobile device by measuring its distance from different reference points. Triangulation is located by computing angles relative to different reference points. So distance versus angle. Fair. So yes, lines versus angles, or distance versus angles. Okay, good. Chat, we learn something new every day. Love it. Ghost Owl said it better. Ghost Owl, thank you. Ghost Owl said distance versus direction. Appreciate it. Brittany in the chat said either way, I'm pretty sure I blacked out. Distance versus direction. Thank you. Thank you very much, Ghost Owl in the chat. So they are looking at taking distance points. I feel like this is just how dolphins navigate in the water, right? They just like use all the distance points to form an image of where things are. Sure. I feel like our Wi-Fi routers can do this and figure out where we are in the house. It's terrifying. When a mobile device is using multiple cell sites, it's possible to utilize the the non-triangulation one, the distance one, distance, to determine a very specific location, typically ranging in meters. Oh, yeah. The jury's going to love that. The second you say meters, the entire jury is going to go, okay, come back to me with the conclusion. So they can use this to determine very specific locations. Essentially, the timing, which is why we need the timing records, right? Because it's how fast things are beep bopping around. The timing records provide a much greater detail of accuracy than regular cell site location, which would be different than it pinged to this side of the tower. And that information only provides cell site and cell sector information, the sector being like what side of a tower or what have you. When analyzing a pattern of life associated with a mobile device, TA can provide accuracy in such detail it's possible to pinpoint precise travel routes, stagnation, and anomalies within a pattern of life. And pattern of life we saw quite heavily in the Murdoch case. It was quite relevant. And I think we'll see pattern of life for multiple phones in this case as well. I think there's going to be a lot of this testimony. They say law enforcement commonly relies on TA records for this purpose. The methodology and accuracy is supported through established, published, and accepted scientific practices. It's like there's methodology that is regularly accepted within a field. Inky19 said, will Emily be talking about the hearing tomorrow? Yes, tomorrow. I'll be covering it tomorrow. Today we're going through the motions that are going to be argued at the hearing, because then I can go, ooh, I'm interested in this one. AT&T was the last of the major providers in the United States to produce TA data for law enforcement. I won't get into my feelings about AT&T. The first TA reports AT&T provided to law enforcement were the result of a software program utilized by AT&T from a third party, Viavi. We're going to go with Viavi Solutions, which offered a software solution. No, Jesus Christ, why are there... Stop it. Which offered a software solution known as Aries OGEO. Don't get me talking about Aries. We got a whole lot to say. No, in using the Aries Geo software, AT&T was able to create and produce TA records for law enforcement, but due to the pricing of the software, it was at a great expense. Yeah, the thing AT&T is going to love to do is spend a ton of money to give us the information. That's not going to happen. It's not going to happen. As a result, only certain law enforcement agencies were provided access to these reports. Well, that's kind of bullshit. If AT&T can't afford the software, you can't pick and choose who gets access to it. But of course, the FBI had been the primary agency given access. Well, did the FBI have to pay for it? Or did AT&T pay for it? And if the FBI was working on this case and had access to it, couldn't they have just grabbed it? Like, using it for some cases and not others doesn't sit well with me. So they say that the TA reports were not common, nor were they created in the normal AT&T ecosystem. I think that's helpful information. This wasn't done regularly. The TA reports were not accessible to the GLDC personnel within AT&T. Okay, but that doesn't mean you can't get them. That means they are not easily gotten. The FBI utilized a different legal compliance unit within AT&T to access those records. Oh, am I shocked that the FBI has an end route? It's like local law enforcement is like, hey, AT&T, and AT&T is like, get in line. And the FBI is like, hey, AT&T, and AT&T is like, oh, I got you, boo. I got you, boo-boo. Don't worry. I hate it here. I understand that resources need to be utilized differently, and this doesn't matter for every single case, but there are cases where this will matter, and you shouldn't not get information just because AT&T has decided that your case doesn't warrant it. Because if you're sitting in Bryan Kohberger's chair, does anything else matter more? Also, the FBI was involved in this case. Why didn't they just grab it? If they can. Let's find out why. I'm sure the defense has a theory. All right. TA reports were not accessible to the GLDC personnel within AT&T. So the state said, we go this way, and they don't give it to us. The FBI had their own unit. The legal compliance unit is separate from the global legal department. When these reports were first made available to the FBI, it was draped in secrecy. I'm shocked. As a result, there is little documentation to rely on when dealing with the early AT&T TA reports made available to the FBI. AT&T developed a new system outside of the Arizo Geo system to produce these records at a fraction of the cost. I'm not surprised. Because people are going to be like, yo, AT&T, give us this information. They're going to be like, that's really expensive. This cost reduction allowed AT&T to provide these records to state and local law enforcement. As a result, GLDC was given access to TA reports in May of 2023. Okay, but how far back could you go and grab them? That's my question. And began providing them to state and local law enforcement in June of 2023. The distinction is that AT&T TA records were available to select law enforcement specifically before the change. All right, timing advance information and records in the state's possession. Kohberger is aware of the fact that AT&T GLDC did not produce TA reports in 2022. There is no doubt that any representative from AT&T GLDC will testify to this fact. Okay. Mr. Kohberger does not contest this claim. The state is also aware of this, as they did not obtain the current AT&T TA records in their possession through AT&T GLDC. They had to utilize the FBI, who went through a different legal compliance unit within AT&T to obtain these records. Okay. At the onset of this investigation, detectives within Moscow Police Department began obtaining cell detail records as part of the investigation. Naturally, in doing so, they heavily relied on assistance from Special Agent Nick Balance with FBI CAST. This is first documented in emails exchanged. We saw some of this in the motions to suppress that were denied. The detectives, Mallory and Payne, were tasked with writing search warrants to AT&T on a number of requests. We saw a lot of this in the motions to suppress. On November 15th, 2022, Detective Mallory requested verbiage via email from SA balance from the FBI in reference to AT&T records. An email string of what was produced by the state in discovery contains a very clear account of the FBI's knowledge of AT&T TA being available. The email to Mallory states, emails. Subject, AT&T tower dump. Nelos became location database of record, or LockDBOR a little while back. List that and timing advance since both are applicable with them now. Nick Balance. Okay, Balance said, ask for this shit. In reviewing this email, there is no doubt the email is in reference to AT&T as it is referenced in the subject line. Additionally, there's an attachment with an email chain that contains the warrant for AT&T. Okay. Detective Mallory was informing Prosecutor Jennings, that's Prosecutor Santa, of the availability of AT&T TA reports and requesting it be added to the warrant. In reviewing the AT&T search warrants that were produced over the next few days after this chain, all of them contained specific verbiage requesting the TA reports just as recommended. And then what happened? We're getting so much more information. And then what? While the available reference email chain is clear as to the existence, availability, and knowledge of the availability to the state regarding the TA reports in November 2022, in July 2024, Kohberger received from the state AT&T TA reports from 2022 in reference to this investigation. These TA reports were not for his phone. Okay, why not? The state turned over 3 separate AT&T TA reports. All 3 reports contain AT&T TA data from November of 2022. In the early phases of this investigation, law enforcement identified 3 AT&T phones of interest, 2 belonging to deceased, and the 3rd phone belonging to a person of interest whom law enforcement was investigating as a suspect. Detective Mallory authored an affidavit in support of a search warrant to AT&T issued November 16th that demanded the AT&T TA records for these phones. All 3 TA reports were produced and are in the state's possession. Okay. The TA report the state disclosed on other phones is what Kohberger has sought relating to his own phone. He requested the report through discovery, and during a motion to compel, Kohberger is aware and will provide testimony in support that the AT&T timing reports currently in the state's possession were not provided to the state by AT&T GDLC. Okay. The reports were produced through another compliance unit. Okay, they've made that clear a couple of times. Kohberger posits that relying on GLDC stating they did not provide the TA reports in 2022 misses the issue at hand. Also, it's for cross-examination. Throughout the discovery process, the state has provided different explanations about TA report availability, but always claiming that it's not in their possession. It might not be in their possession, but could they get it? And do they have to? Because if they can get it, that is open season for cross-examination. If the state can get information and opts not to, that's literally what cross-examination is for. You can't just not cross-examine on it. The state obtained search warrants in December 2022 where the state sought AT&T TA reports for Kohberger from November 2022. Okay. The search warrant for Kohberger's phone data contains identical verbiage as was used requesting the TA reports issued for the other phones in 2022. The same process of serving the warrant was followed. And then the second AT&T warrant contained the title AT&T Mobility Carrier Request. Okay. Kohberger has sought TA records related to his own phone and litigated the issue. During the course of litigation, the lead detective testified he had seen Kohberger's timing advance reports. And Kohberger has documents produced with the search warrants that instruct AT&T to provide timing advance data. Discovery documents contain emails about including that request in the search warrants. Kohberger provides these as exhibits. Kohberger has the right to confront evidence against him. So the state is saying we don't have it, and the defense is saying All signs point to yes, you do have it because you asked for it and you were given it on all the other phones you asked for it. So where is it? Kohberger has a right to confront evidence in the case against him. Yep. His constitutional protections must be afforded a full and fair opportunity to cross-examine state's witnesses. AT&T TA reports are available, just not from that other group. The state has produced reports that were prepared before GLDC produced them for law enforcement. TA reports relating to him exist, yet the state has not produced them. So where are they? The state now seeks to limit his cross-examination and their lack of disclosure by hiding behind half-truths. Yeah, that's not going to fly. Kohberger must be allowed to explore the state withholding evidence. Yeah. Let's see how the state replies, because the state replies and then the defense replies back to the state. If you were able to get that information as to other phones and the search warrant all has the same language, where is it? Look, I'm not going to jump up and down about splitting hairs over whether it's an alibi or whether it's cross-examination or whether it goes to prove that the state can't prove their evidence. But the state can't split hairs on, well, we didn't get it from party A. Okay. But if you got it from party B, you still have to turn it over. So just being like, hey, Your Honor, party A didn't give it to us, and then ignoring that party B exists and might have given it to you, that doesn't work. You can't split hairs on discovery. Okay. Let's see what the state has to say in their reply before we get to the defense's reply to the state's reply. Because this is the state's reply to the defense's objection. Timing advance records refer to data that's used by providers to estimate the location of a mobile device. Great. Carriers do not retain this data indefinitely. If you turned over this exact information for other cell phones, and for all of you asking, Emily, have you read these before? No, we're doing this together. If you turned over this exact data for 3 other phones from the same period of time, and you requested it in the same way, in the same search warrant language, I don't give a fuck if it's not held indefinitely because you should have it. Don't start being like, well, we downloaded it all from the Sallyport video and we downloaded it and then it got turned over to Trooper Proctor and then we don't know where the fuck it went. I don't know. We had days of video and now all you've got is, I don't know, a couple hours. I don't know where it went. It just poof. If there were records from the same time period turned over, telling me they're not held indefinitely also doesn't tell me how long they're held for. I bet they're held for longer than a couple of years. Also, if you got them on other phones, how did you not get them here? Regarding AT&T, before June 2023, AT&T retained timing advance records for 7 days. How do you have them on other phones? Then how do you have them on other phones? These records were not routinely provided in response to legal demands prior to June 2023. It seems that that's why you put the specific request into the search warrants. It's not like you don't have this information on other phones. And if you have this information on other phones, How do you not have it on the defendant's phone? If you had it on none phones, then I get it. These records were not routinely provided in response to legal demands. Great, everybody agrees on that. After June 2023, AT&T started providing these records pursuant to legal demand and began retaining timing advance records for 13 months. Okay, but you weren't looking for records from May of 2023. You're looking for records from November 2022. In this case, the homicides occurred on November 13th, 2022. Bryan Kohberger was identified as a suspect December 19th. Search warrants. Are you saying that they were overwritten before the search warrants? Because then wouldn't everything have been overwritten? Like, it's not picking and choosing. The defense motion did a really good job of raising a lot of questions in my mind. And so far, the state's response is not answering those questions in my mind. Search warrants for his AT&T records were executed on December 23rd, but there were more after that, weren't there? At this point, timing advance records were not available for Bryan Kohberger's phone to cover the relevant time period. From everyone, you're missing some information. Not available from everyone or not available from the one place. Despite defendant's repeated assertions, the fact of the matter is that AT&T did not provide timing advance records to law enforcement for Bryan Kohberger's phone. So the state is saying, we don't have it. But how do you have it for other phones then? I'm going to need you to explain it to me. The state is attaching affidavits from AT&T verifying that the state did not receive timing advance records from Kohberger's phone. Okay, we're going to look at the exhibits on this one. Based on the above, statements or inferences by defense counsel or their witnesses that there is additional evidence that could have been provided or was not provided is simply not correct. You've left so much information out. Emily, just read the affidavits. Let's read the affidavits. Let's see. This is from the GLDC. Oh, the defense knew this is exactly what was coming. Laura said they knew the victims within 7 days. Took longer than that for Bryan Kohberger. Am I missing something? I understand that, but they did not say that. That might be the explanation, but they didn't explain it that way. I'm not trying to, the state needs to explain it to me at this point. Like, explain it to me. Why you have it for some and not all. That's, I don't like how vague the response is. The state is just like, we don't have it. And again, the defense said this location, the GLDC, did not have them at that time. AT&T maintains records made at or near the time of the occurrence of the referenced matter set forth by or from information transmitted by a person with knowledge of those matters. Okay. Responsive to search warrant from December 23rd for records between November 12th and November 14th related to the 13th homicides. AT&T did not provide timing advance records for the phone number and were not timing advance records were only available if requested within 7 days of the specified time frame. I need to go back and look at when they requested them for the other phones. I'm going to switch back to that. The timing advance records were not included in AT&T records responsive to the referenced search warrant because more than 7 days had elapsed between November 13th and the date of the warrant on December 23rd. And then they attached the warrant. This is another GLDC certificate of authenticity. Timing advance records were only available if requested within 7 days of the specified time frame. More than 7 days elapsed between November 13th and December 23rd. Other search warrant. Okay, I'm going to go back and look at the defense objection because now I have questions. So, and I want to see if the defense gave timing of this. Let's see. These emails were from November 15th. When were these served? Let's see. Well, the above referenced email chain is clear as to the existence, availability, and knowledge of availability to the state regarding the TA reports in November of 2022 and July 2024. Kohberger received from the state AT&T TA reports from 2022 in reference to the investigation, not for his phone. When were those requested, and why didn't the state put that in their reply? All three reports contain AT&T TA data from November of 2022. In the early phases of this investigation, law enforcement identified 3 AT&T phones of interest. The search warrant was authored on November 16th. And that's the difference. So for all of you who pointed it out, you guys are like, I needed to go back and look at the timing. Well, all of you pointed it out. This first search warrant happened November 16th. Kohberger's phone, it seems, was not identified yet. Why didn't the state just explain that in their reply? I really hate that the response is, we don't have it. It makes sense that you don't have it if all of these were requested within the time period. These were all requested within 7 days. Jordan says, was Kohberger a suspect early enough? He wasn't a suspect until a month later. But it looks like these search warrants were issued November 16th. That's within 7 days. The TA report the state disclosed on the other phones is what Kohberger has sought relating to his own phone. But it looks like those were requested on November 16th. Kohberger's phone wasn't requested until December. Why the fuck wouldn't the state just say that in their reply? Because it doesn't make any sense to not just respond with that. This doesn't make any sense. All right, let's go to the affidavit and take a look. They also say that there was a way to get that report not going through GLDC and that the state did that, but the state is saying that if you go through not the GLDC, they still don't have them more than 7 days. So asking for them in December isn't going to get you there because it's still beyond 7 days. But I don't understand why they wouldn't explain it. The state's just saying, we don't have it. We don't have it. Okay, can you explain why you don't have it? Also, why would you be making a motion in limine to preclude cross-examination on this if the answer is truly those search warrants were written within 7 days. This one wasn't identified within 7 days. And so it did, in fact, no longer have that data because we didn't identify it within 7 days. The answer just doesn't make any sense. Because the answer is like, you can say it all you want, we don't have it. I'm confusion. I'm really interested to hear the oral argument on this, because I imagine the court is also like, okay, so the exact same process which resulted in the TA reports being produced in November was repeated in December. It seems that the issue, though, is that if you repeat that in December, I'm going to scroll back up in the state's motion here. If you repeat that in December, it's too late. Where is the thorough response from the state on this? Before June 2023, AT&T retained timing advance records for 7 days. Those records were not routinely provided. And then they started getting held for 13 months. In this case, the homicides occurred November 13th. Kohberger was identified December 19th. Search warrants for him were executed December 23rd. At that point, the advanced timing records were not available for Kohberger's phone to cover the relevant period, November 13th. Why don't they just include when the other search warrants were written? It seems that the other search warrants were written November 16th, and that would fall within that 7-day time period. The fact of the matter is that AT&T did not provide timing advance records to law enforcement for Kohberger's phone. So the state is saying they don't have it. Based on the above statements or inferences by defense counsel or their witnesses that there is additional evidence that could have been provided or was not provided is simply not correct. I still think you get to cross-examine on it. And then your experts can explain, we keep this for 7 days. The search warrant came in more than 30 days later. We don't have it. Why is this so hard? Like, okay, the defense responds to that with an affidavit from their expert. I'm interested to see what they say. The state is saying essentially like, this is a nothing burger. We're not even going to waste our time responding. And I wonder why. All right. Thank you, Miguelina. Let's notice of filing affidavit in support of defendant's objection to the state's motion in limine regarding AT&T timing advance records. Okay. Now my document's fighting with me. All right. Document, behave, move over. Hold on. This doesn't make sense. For those of you asking, why would the detective say he had seen it, which was in the motion? I have so many questions. Somebody asked in the chat, could it be they don't want to open the door for alternative suspects? They don't get to make that choice. And if they made that choice, that gets your case dismissed immediately. They are not allowed to just be like, this might exculpate this defendant, so we're just gonna not. That gets your case dismissed. That is the square purview of Brady. Like, this might prove that he didn't do it, so we're just not gonna grab it. That's not okay. But if they didn't identify him as a suspect until a month plus later, and if things did overwrite within 7 days, that's not them just willfully letting it overwrite or ignoring it. But I need more information because the defense is alleging, hey, This individual said they saw it. Well, where do we know that from? So the defense filed an affidavit in support of their motion. And let's take a look. This is an affidavit of Syray in support of the objection to the state's motion. We read the objection. The objection is, yes, this one place doesn't provide those records. This other place does. And you can't just willfully ignore evidence and just let it be destroyed. If you don't have a suspect and that time passes, that's different. Let's see what happens. Plant Hoarder said, was finding Bryan all based off an anonymous tip? It seems to be based off of DNA. And that the DNA was the tip. All right, this is Syray affidavit in support of the defense opposition to the state motion that seems to say you can't cross-examine on this, which is a really weird motion in limine. I've been working in the field of call detail record analysis for over 25 years. I became a certified police officer in the state of Arizona in 1996. I worked with my first set. 1996 was not 25 years ago. Stop it. I feel attacked. Became a certified police officer in the state of Arizona in 1996. Worked with my first set of AT&T records in 1997. Spent nearly 20 years in law. 1996 was 7 years ago. Like maybe 10. Chat, shh. Let my Delulu loose. 1996 was 10 years ago. Shh. That's it. That's all. Chat, let me live. I spent nearly 20 years in law enforcement in the primary role of a detective. I worked hundreds of death investigations, consulted over 1,000 homicide cases in my career. In my role as a detective, I gained extensive experience utilizing call detail records and exploiting cellular networks for investigative related purposes. In 2014, retired from law enforcement, started a business called ZX that created software for law enforcement to map and analyze call detail record. That's wise because they're bad at it a lot of the time. As part of that business, we maintain software that support every known call detail record provided to law enforcement in the US. To date, the system has analyzed over 3 billion calls from call detail records provided by cell phone companies. LexisNexis purchased ZX. Bro, congratulations on that. He was like, this is a huge problem. Let me fix this problem. And LexisNexis is like, let us back up the Brinks truck to you and give you all of the money. Well played. Well played. In 2021, LexisNexis purchased ZX and to date is still using and selling the software I created. As a result of this experience, that's a lot of experience. I have worked directly with engineers at the cell phone companies for over 2 decades, and I am intimately familiar with the type of data they maintain. I would imagine so if you're making software to solve problems. Best way to build software. How do you choose a software? You identify a problem and solve the problem. In addition to my law enforcement experience, I've instructed classes utilizing cell phone records in criminal investigations for nearly 20 years. It seems like this individual has a grasp of technology. I've had over 30,000 law enforcement officers attend these courses. Right. I created the first geolocation cellular investigation subject matter expert course in this field because law enforcement was bad at it. Right. And the cell phone companies did not do a great job of explaining things to law enforcement. You need a bridge in between those conversations. And it looks like he taught people to become that bridge. As a result of this work, I established well-known and used best practices. He's like, I'm not the expert in the field. I created the field. Methodology, you say, I created the methodology. This is like the dude of the dude. As a result of this work, I've established well-known and used best practices within the discipline of call detail record analysis. Over 1,000 law enforcement agencies have attended my courses on the subject matter of cellular record analysis, including the FBI, ATF, Marshals, DEA, DHS, all the things. Through my work in this discipline, being able to teach a thing and then also building a thing and then also working with a thing, that's a lot. Through my work in this discipline, I am regularly consulted by the prosecution on investigations around the world. As a recognized subject matter expert in the field, I have testified on the matter more than 100 times throughout the U.S. in both federal and state courts, I imagine. Apart from this case, all of my testimony in the field has been on behalf of the prosecution. Right, because law enforcement background. It is only in rare cases and circumstances I have ever considered working on the side of defense. Oh, juries are going to like this expert. We'll see how he testifies, but juries are going to like this expert. It's like, I worked in law enforcement. I understand law enforcement. I train law enforcement. I generally work for the prosecution, but in this case, I have thoughts. Interesting. I've worked extensively with timing advanced data from cell phone network providers over the past 15 years. I have testified to the use of timing advanced data numerous times. I've created and taught hundreds of classes on the subject matter. I am extremely familiar, it sounds like it. Timing advanced records are maintained by cellular network providers that provide a time measurement. This time measurement refers to the amount of time it takes a radio signal to travel from a cell site to a mobile device and back to the cell site. It's an easy explanation. Given this signal travels at a known constant speed, the speed of light, it's possible to use the measurement to determine the distance the mobile device is from a known cell site. Known speed, and then you can solve for distance. When multiple cell sites record timing advanced data in short periods of time, it's possible to use trilateration to determine the location of a mobile device. The use of timing advanced data in this matter is one of the most accurate ways for law enforcement to locate a mobile device. Given these records are available in a historical context, it is possible to conduct an analysis of timing advanced data to pinpoint historical locations of a mobile device at a given date and time. Are these stored by the cell site then? It's also possible to determine routes of travel, stagnation, and when a mobile device is powered on and off. It seems like the defense had this conversation before they wrote their motion, though they should have just directly used his explanation. It's better than theirs. As a result of its accuracy, requesting timing advanced data has become a standard practice for all law enforcement in the US and is regularly requested. Well, it sounds like they requested it in this case and requested it too late because he wasn't identified. In August of 2021, I was approached by the FBI. To assist in analyzing a type of record set identified as AT&T Timing Advance Report, and it was the first time I had been made aware of this type of data from AT&T. Upon request, I can provide the date, time, location of the FBI agent I assisted with the record set. As of the year 2021, AT&T had not officially released the Timing Advance Report to law enforcement. Therefore, the ZX software program did not yet support AT&T Timing Advance records. Well, that makes sense. If AT&T doesn't support it, okay. So that's 2021. As a result of this interaction with the FBI, I obtained a copy of the Timing Advance Report from the special agent and forwarded it to our software engineers to write the code within the system to support future uploads of this report format. The next day, I was informed by the special agent the AT&T Timing Advance Report was not supposed to be released and viewed outside the FBI. The FBI's like, shit, buddy. Give it back. I need you to give it back. Can you give it back? Please, we need to put the shit back in the horse. I wasn't supposed to give that to you. That's our eyes. That's our eyes only. Just damn it. He's already converted it into his commercial program. The next day, the FBI was like, fuck, no, sorry, you can't have that. Was not supposed to be released or viewed outside the FBI, and that individual requested I return the report and not have any software development to support the data they had shown me. I did return the report. However, due to the interaction explained here, there is a paper trail documenting the facts of this interaction. I have firsthand knowledge that AT&T was providing the FBI with advanced timing reports prior to August of 2021. So it's possible, but not readily accessible to get these reports. AT&T legal demands. During my career working with call detail records from every cell provider in the United States, I've been involved with thousands of cases. I wrote and provide custom search warrants for every provider and distributed them. Okay, I've worked with the AT&T Global Legal Demand Center for over 15 years. Firsthand knowledge that AT&T GLDC is one way, not the only way for law enforcement to obtain call detail records from AT&T. I get that. I have questions about the 7-day timing. Right now, that remains my biggest question. There are multiple ways to get this, but does that come with a ticking clock? Okay, you can request this a bunch of different ways. You can't request anything until a suspect is identified. So that is my biggest question at the moment. Are you going to tell me you can get this beyond that 7-day window? That's what I want to know. I have firsthand knowledge that there is another way to obtain call detail records from AT&T without going through GLDC. Okay. Does that have a clock on it? Over the course of many years, AT&T has had several different programs in partnership with federal law enforcement, primarily the FBI, that allowed call detail records to be disseminated to the FBI without going through the standard process. We heard about this in the defense motion. I imagine this is where they got that information from. I have firsthand knowledge and experience working with individuals at AT&T associated with those programs. I am completely on board with this is probably available in other ways. You don't need to convince me anymore. I'm with you. But is there a clock on it? The state is correct in their claim that the AT&T GLDC does not provide law enforcement with AT&T timing advance records until May 2023. As a matter of fact, well, actually, in May of 2023, the working group known as GLDC had only begun their storage of timing advance records. So they didn't start storing them until May 2023. The first release wasn't till June. This was all in the defense motion. Again, I want to know what the clock is on this. During the investigation, law enforcement obtained the following AT&T timing advance data. 2 of the victims had AT&T phones, and law enforcement obtained AT&T timing data from both of their phones. But it looks like they requested that within like 2 or 3 days. Law enforcement had developed an early investigative lead in the case. That person had an AT&T phone at the time of the crime. Law enforcement obtained his AT&T timing advance data. On what date? Law enforcement also requested a tower dump consisting of AT&T timing advance data. This request involved AT&T providing all of the connections between 2 specific cell sites in Moscow during a 2-hour period. The data produced was AT&T timing advance data. In all, there were over 3,800 AT&T mobile phones identified in the timing advance tower data. Okay. The AT&T timing advance data was obtained by the FBI using an internal source at AT&T. A forensic examination of the AT&T timing advance records in the state's possession show who they came from at AT&T. Okay. None of this explains to me yet why Kohbergers should be expected to be in there, though. There is work product in the state's possession created by the FBI showing the AT&T advanced data was not only obtained but regularly referenced and used in the course of this investigation. For whom? Its existence is well known to the investigators and prosecutors. Okay. Tara said, Bryan's data should have been included in the 3,800 dump. Not necessarily. it's during a 2-hour window. So I don't know what that 2-hour window is, and I don't know what his phone was doing during that window. They only tower dumped a 2-hour window. If his phone was off or in airplane mode or whatever during that 2-hour window, it wouldn't be in that dump. And if his phone was included in that tower dump, if it was, then they still wouldn't have enough to get a search warrant until they have more information. You can't just get a search warrant from everyone whose phone connected to that tower within that 2-hour period. It's not sufficient. So there would have to be more. So if the phone was off, it's not included. If the phone's in airplane mode, it's not included. And even if it's included, it doesn't necessarily mean they have enough to get a search warrant during that window. Chain of custody. The state has provided the certificate of authenticity to the defense in relation to the timing advance records. The certificate of authenticity was created in April of 2024. I've previously worked with and am familiar with the person who created that. The certificate of authenticity states I'm qualified to authenticate the records attached here too because I'm familiar with how the records were created, managed, stored. I have personal knowledge that in the event that Mr. Gordon was required to testify, he would clarify that prior to May of 2023, neither he nor the AT&T GLDC working group was involved with the AT&T timing advance records. It seems we all agree on that. And by all, I mean them. Additionally, there is forensic evidence contained within the records that indicate they were not produced by AT&T GLDC, nor were they produced in the year 2024. With regard to the other phones, in reviewing this data, I've contacted and communicated with Mr. Gordon to clarify the chain of custody related to these records. He and an AT&T legal representee informed me that Gordon would not be the individual to certify these records if required to do so. Well, that's a completely separate matter. I'll tangent on that later. In my review of this information, there's evidence to suggest a chain of custody involving these records and the COA were produced well outside of AT&T's normal practice. That's a huge asterisk red flag, but separate from the question we're trying to answer now. There is misinformation and data associated with this request. The prosecution's prior claims that AT&T timing advance data did not exist in 2022 further complicates the issue. I need more information. The prosecution has been incredibly vague in this. The lawyer saying this information does not exist in 2022 when the information does not exist from their point of contact is narrowly parsed. And I don't know if that is a problem or not a problem yet, because I still have questions about that 7-day window. Because if it's outside the 7-day window, it doesn't exist, period. And no one has yet said the 7-day window at this period of time is not the window. Outside of 7 days, it doesn't exist. Objection vague. All of it. I'm going to be chomping to hear the oral argument on this motion tomorrow. The prosecution's prior claims that AT&T timing advance data did not exist in 2022 further complicates the issue. Well, we'll see if we're splitting hairs or not. It's my expert opinion that any testimony proffered on behalf of the FBI or AT&T on this matter would clearly reveal these issues. Yeah, you should absolutely be able to cross-examine on this. 100%. Evidence in direct contradiction of the state's motion. In my review of this investigation, I've read numerous emails sent and reviewed by law enforcement pertaining to their investigation. One such email dated November 15th, 2022 was sent to the prosecutor Ashley Jennings. Oh, not Santa prosecutor, other prosecutor. At her email address. This email is from Detective Mallory. The email is informing the DA or the prosecutor of the detective's contact with the FBI.
The FBI!
And the information that AT&T can provide timing advance data to make sure it is listed in the search warrant. Okay. Jennings did not respond to the email inquiring on the specific verbiage needed to obtain the timing advance. This email is abundantly clear evidence that the prosecutor was aware of the existence of AT&T timing advance in 2022, but also shows her intention to obtain it. Okay. The email communication with the prosecutor is the same prosecutor who filed this current and contradictory motion stating that AT&T did not produce timing advance records in 2022. We're going back to the state's motion. Is that what the state said? All right, this is the state's motion. Emily, is this why you print out everything? Yes. When I am parsing through motions that I am going to argue in court, which is not what I do anymore, but now I'm fucking confused and invested, I print them all out so I can flip back and forth. Welcome. You're now in it with me, law nerds. We're not going to get to some of the other stuff today because I'm so fucking confused and annoyed. Like, what are we doing? Okay. Back to the state's motion. The state has been advised and will offer documentation that AT&T records are produced by their Global Legal Demand Center. Normally produced? Regularly produced? AT&T GLDC did not begin producing timing advance records until May 2023. That point seems to be clear. All records for defendant's phone were obtained from GLDC in December 2022. The state intends to supplement this motion with additional information from the FBI and or AT&T prior to the hearing. Okay. Any statements or inferences by defense counsel or their witnesses that there is additional evidence that could have been provided or was not provided is a mischaracterization of the evidence. It sounds like if you requested it within 7 days, it could have been provided. But if you request it outside of the 7 days, it can't be provided. It also seems that AT&T records are produced through GLDC, but they're not exclusively produced through GLDC. You guys said flip back to page 1. Yes. But page 1 has the same information. The state brings this motion based on defense counsel's repeated references to the alleged existence of AT&T timing advance records related to defendant's phone. They're saying that that they don't exist any longer. And they don't want I think it's proper grounds for cross-examination. But again, the defense is saying that the prosecution is splitting hairs and that it is literally true that AT&T does produce records through GLDC, but does not exclusively and only produce records through GLDC. And that defendant's records were produced in December 2022. Let's go back and see if they address the 7 days in this affidavit. The expert for the defense says that the motion is contradictory, stating that AT&T did not produce timing advance records in 2022. But they don't really say that. They said that those records weren't produced by GLDC, and everybody agrees with that. We're going to end up splitting a lot of hairs in this to get to what is actually meant. The defense expert says there's clear and convincing evidence that not only was the FBI able to obtain AT&T timing advance records in 2022, but they did so with the knowledge of the prosecutors involved in the case. It seems that they told prosecutors they were asking for it. Missing AT&T timing advance. In my review of the investigation and based on my training and experience, it is incredibly unusual that the defendant's AT&T timing advance records were not obtained by the FBI. Can someone just explain to me if this window is real or not? Because they have not contradicted the 7-day window. The FBI demonstrated that their ability to obtain AT&T timing advance in November of 2022 by obtaining AT&T timing advance records on over 3,800 mobile devices, none of them being the defendant's. I can't tell if that's a footnote or not. And that's the cell tower dump. Doesn't look like a footnote. So the cell phone tower dump, to me, is different and separate and apart than asking for that information for a specific phone. They say when it comes to location data from AT&T, timing advance data can be some of the most accurate data available. Okay, we have heard this over and over again. A timing advance report would be asked for as standard operating procedure. It seems that they asked for it. Moscow Police Department, by way of the FBI, with knowledge of the prosecutors, demonstrated their awareness of this procedure when they obtained AT&T timing advance data on over 3,800 mobile devices right from the tower dump. When detectives and prosecutors requested and served 2 different search warrants to AT&T on the defendant's AT&T account, they requested the exact same timing advance data they previously did when they obtained the timing advance data from AT&T on over 3,800 mobile devices. They also maintain the same process in utilizing the FBI to serve the legal documents on AT&T. There's no difference in the verbiage. Okay. They go on to say on December 23rd, 2022, the FBI sent a communication directly to AT&T specifically detailing their request for defendant's AT&T timing advance records. There was no reason to believe AT&T would not respond to this request. It sounds like AT&T responded saying that it doesn't exist, because that's what we just saw in the objection. Doesn't the expert have that? Maybe he didn't. It's my expert opinion AT&T timing advance data did exist for the defendant's AT&T mobile device in 2022, and that it was requested from AT&T by the investigators involved in the case. The investigators previously demonstrated their ability to obtain AT&T timing advance in 2022. Failure to produce the defendant's AT&T timing advance data is either a gross deviation from standard practice or intentionally withheld from release in discovery. It's my expert opinion in reviewing all the evidence that has been disclosed by the state that the AT&T timing advance data was available on the defendant's phone in 2022. There is overwhelming evidence showing the state obtaining and using AT&T timing advance data in the course of its investigation in 2022. But a tower dump from a 2-hour window and requesting a search warrant on a specific phone aren't the same thing. There is no doubt the author of this current motion, Prosecutor Ashley Jennings, knew or should have known AT&T timing advance data did exist in 2022. She was directly involved in the legal process obtaining it and was aware of work product created from it to further the investigation. The current motion is a deliberate misrepresentation to the court to further conceal false statements used to obtain probable cause against the defendant and conceal exculpatory evidence from discovery. That's a big allegation. But it doesn't address the overwrite period at all. Like at all. I'm prepared to provide witness testimony and relevant exhibits to support all my opinions contained in this affidavit. It's my belief that this evidence is beyond clear and convincing. I mean, the court's not asking you for a legal standard. And will be supported by any competent expert in the field who reviews all the data. This is not a battle of the experts. The evidence supporting the opinions in this affidavit is overwhelming. I think they're all talking about the same thing. In my nearly 30 years of working with and for prosecutors all over the United States, I have never witnessed such a deliberate attempt by prosecutors to mislead the court on evidence in such plain sight. That is a big allegation. Anyone making such a claim would have to believe the court is incapable of reviewing. Oh, he's challenging the judge. Oh boy. Anyone making such a claim would have to believe the court is incapable of reviewing physical evidence in possession of the state and defense. It raises to a level beyond a simple miscommunication or oversight and is clear and intentional misrepresentation in hopes to conceal a much larger issue. That is a large allegation. I don't know if I am on board with that allegation. There are questions that are unanswered. And he's like, Your Honor, they think that you can't read. I respectfully request the court give this affidavit the due attention it deserves to explore these issues further. Oral argument on this is going to be real interesting. This was authored the 25th day of March. Those are really big allegations. And this affidavit was from the 25th of March. The state's reply, let's switch back and then, I am getting real close to a hard stop. It's going to be fine. It's going to be fine. The state's reply is from the 24th. The affidavit's from the 25th. Did he review? I don't know if he reviewed the state's response. Let's look at the state's response. The state's response says, timing advance records, we know this. The collection of data is necessary for the cellular network to work properly. Carriers do not retain this data indefinitely. Regarding AT&T, before June 2023, AT&T retained timing advance records for 7 days. No one has challenged that proposition. And that's the biggest question for me. The state has not been clear in what they're saying. The defense has very big allegations in this. And so I have questions. Before June 2023, the records existed for 7 days. So in 2022, the records existed for 7 days. By the time they identified Kohberger as a suspect, they are saying that 7-day period had expired and therefore no records existed at the time they wrote the warrants. But the prosecution isn't super clear in their explanation at all. AT&T retained timing advance records for 7 days. No one has challenged that. So if that's true, then in December, those records didn't exist by the time they identified somebody to gather them. These records are not routinely provided in response to legal demand prior to June 2023. Yeah, but you specifically asked for it, though. After June 2023, AT&T started providing these records pursuant to legal demand and began retaining them for 13 months. No one has challenged that that's true or not true. In this case, the homicides occurred November 13th. Kohberger was identified December 19th. Search warrants for his AT&T records were executed December 23rd. At this point, timing advance records were not available for Bryan Kohberger's phone to cover the relevant time period. Despite defendants' repeated assertions, the fact of the matter is that AT&T did not provide timing advance records to law enforcement for Bryan Kohberger's phone. And it sounds like they didn't. The expert for the defense is saying the state is hiding this and saying it doesn't exist. And it seems like the state is saying by the time we requested it, it didn't exist. If the state is saying these records don't exist at all in 2022, then that's not accurate. But it seems that what the state is saying is that by the time we requested these records, they did not exist. And that's literally true and has not been challenged. This is going to be interesting to see them argue tomorrow. The defense is saying somebody referenced seeing them. If the state has them and has not turned it over, that's a huge issue. The state is saying they don't have them. Let's see. The fact of the matter is that AT&T did not provide timing advance records to law enforcement for Kohberger's phone. The state is attaching affidavits from AT&T verifying that the state did not receive timing advance records. And then the defense is challenging whether those certificates are accurate. Based on the above statements or inferences by defense counsel and their witnesses that there is additional evidence or could have been provided and was not provided is simply not correct and should not be allowed. Again, I think that's a matter for cross-examination. And then they put in the affidavits saying that AT&T provided records for phone number responsive to the search warrant. AT&T did not provide timing advance records for the phone number because timing advance records were only available if requested within 7 days of the specific time frame. Timing advance records were not included in AT&T's records responsive to the search warrant because more than 7 days had elapsed. No one has challenged that that time period is inaccurate. So no one has challenged that that time period is inaccurate. I have a lot of questions. I have a lot of questions because there are multiple agencies within AT&T. So, unfortunately, I still have questions, chat. And I am sorry that I still have questions. We did not get to nearly half of the motions in limine I had hoped to cover today. We did not get to the text messages. We did not get to the alibi. Oh, we did get to the alibi. We did not get to the Amazon click activity. We didn't get to the bushy eyebrows of it all, which we are going to look at real quick because I promised we would look at bushy eyebrows. But when it comes to the AT&T timing advance records, I still have questions. The prosecution is arguing that the defense shouldn't be allowed to cross-examine on this. The defense is saying, literally, you can't do that. And we think you're not turning over information that you have, and we think you're doing it willfully. And the prosecution is saying, no, by the time we identified Kohberger as a suspect, those records in 2022 had timed out, overwritten, no longer existed by the regular course of business that they are only kept for 7 days. And now the process is different. The defense has not asserted that those records could be obtained beyond that 7-day window. They have not asserted that Bryan Kohberger was identified and search warrants were issued prior to those dates when it would have been turned over. The defense has asserted that law enforcement said that they saw timing advance records with regard to Kohberger's phone. if they did exist in the possession of law enforcement, that is going to be a problem for law enforcement. But the prosecution and AT&T both have said, well, those could be obtained, but in that 7-day window, they weren't obtained. So we got them in 2022 for the phones that we had identified. We had not identified Bryan Kohberger yet. We did not request them yet, and they timed out. And the defense has not challenged that timing. So I'm left to wonder if that 7-day period in 2022 is the truth. I have a lot of questions, but I'm surprised that the defense did not highlight that 7-day period if they know that records can be obtained outside of that window. Because it seems that the defense is arguing solely that the prosecution said those records didn't exist, but in 2022, those records do exist and can be obtained. And the prosecution is saying they can be obtained within 7 days, but if they're not obtained within 7 days, then they do not exist. So I don't know if we have a splitting of hairs or a very large issue. If the prosecution got these records and didn't turn it over, that is a very large issue. If the prosecution requested those records and AT&T came back and said those no longer exist, then that is not a very big issue. Let's take a look at Bushy Eyebrows real quick. I'm very interested to hear how this goes down in court tomorrow. If y'all want to be in court tomorrow, and Miguelina, will you just ping Chris and let her know I am zooming the best I can? So if you want to make sure you don't miss court tomorrow, make sure you download the Lawnerd app. We built it for you. I love having you guys in the Lawnerd app so we can always keep you in the loop. Go and get the Lawnerd app at lawnerd.com. You're going to need it. We're going to be in court tomorrow. I want to look at the Bushy Eyebrow motion just real quickly. We got so deep into the weeds on the tech stuff because the defense is alleging that this is a huge issue. And the prosecution has not spelled it out clearly. But that 7-day window, that's a sticking question for me, and I want to know. That's the answer I want, and we do not have it yet. All right, so I'm going to wait and see where we're at tomorrow. This is the wrong tab. This is the correct one. This is the defense motion in limine regarding witness identification by Bushy Eyebrows. This is Kohberger's motion, which is asking the court to exclude any evidence referencing Bushy Eyebrows. And again, this is probably a matter for cross-examination. This probably just goes to the jury. The defense asserts that rules 403, 601, 602, and the Idaho Rules of Evidence bar witness DM from using the words Bushy Eyebrows or identifying Kohberger in that manner. The issue of witness identification is a critical one in a trial that is the subject of much litigation. This is because the reliability of witness identification is the linchpin in determining the admissibility of identification information. I don't think this case is based on eyewitness identification by even part. In this case, the description provided by DM is unreliable and should be excluded. So they are asking to exclude DM's description of what they saw that night. Although she has never identified Kohberger, testimony from DM from the witness stand describing Bushy Eyebrows while Mr. Kohberger sits as the accused at trial will be as damning as her pointing to him and saying, he is the man that did this. So the defense concedes the state of his eyebrows? I don't know if they're going to be able to bar her from the statements she gave to law enforcement and observation, I think this is grounds for cross-examination. But let's hear it out. When considering whether identification by a witness is reliable, the Idaho Supreme Court applies a balancing test, which looks at the opportunity of the witness to view the criminal at the time of the crime, the witness's degree of attention, the accuracy of the prior description. I don't think this witness is going to identify Kohberger in court. I think they're going to be asked, what did you see that night? And then be cross-examined on that. When the balancing test is applied to the facts of this case, the reliability of the witness identification is non-existent. She didn't make an identification. She made a broad description. I had a witness in a case that said they saw a person dressed all in black. And when asked to describe the person, the witness said that person's a ninja. That was it. Dressed all in black, head to toe, all black clothing. Cannot tell you. Man, woman, age, race, nothing. Ninja. Dressed all in black, head to toe. That's it. And we're like, that's what you saw. I mean, we're not asserting that a ninja committed this crime, but that's what you saw. That's your description. That's what you saw. And we're not going to ask you to describe it anymore. I saw a person dressed all in black. That's all I can give you. Fine. This witness can be cross-examined on that and is allowed to say what they saw. And then the credibility of that witness is allowed to be challenged. How much sleep somebody had gotten, whether or not they had been drinking or imbibing in other ways, all of those things. Stress, the lateness, the relative light or darkness of a location, the subsequent stress, all of that goes to cross-examination, I think. They say that when the balancing test is applied to the facts of this case, the reliability of witness identification is non-existent. They don't identify him. DM is the only person alive who is known to have seen the intruder. She only saw the intruder briefly. Her recollection or lack thereof is filled with uncertainty, fuzziness, influence of alcohol, dreaming, and sleepiness. She did not see the intruder well enough to describe him to a composite artist. After Kohberger was arrested, she did not recognize him from a photo. Okay. So then saying the intruder had bushy eyebrows becomes for the jury to describe what a bushy eyebrow is. Relevant facts. Interviews on November 13th, 2022. On November 13th, 2022, DM was inside the house when the murders occurred and saw a figure dressed in black when she peeked out of her bedroom door around 4 a.m. Shortly after seeing the intruder, she went downstairs to BF's room. The two girls fell asleep. 8 hours later, a 911 call was made from BF's phone at 11:56 a.m., more than 8 hours after seeing the intruder. DM was interviewed by law enforcement at the scene and at a police department. It was confusing to DM that the intruder looked at her but did not come towards her or say anything. When describing the intruder to Officer Nunez at the scene, she described the height, build, and clothing. Her description did not mention eyebrows. When she called BF before going downstairs to BF's room, DM said that she was kind of in and out of it. I was really tired. Later, when she was interviewed at the police department, Detective Mallory inquired about facial features and asked DM if she knew what color the intruder's eyebrows were. She did not know the color of the intruder's eyes or eyebrows. Yeah, normally you would ask the color of eyes. That's odd to ask the color of eyebrows. Okay. She did not know the color of the intruder's eyes or eyebrows. Everything was kind of blurry, like I don't fully remember it. During the Mallory interview, DM again mentioned that she was in and out of it because she was so tired. On November 13th, law enforcement took pictures of DM's room. On November 13th and November 19th, on the walls in her room were many pictures of eyes with prominent eyebrows, many of which she had drawn. Some of the eyebrows are heavy, voluminous, puffy, or perhaps subjectively bushy. There is a separate motion in limine regarding DM's room. According to Detective Lake, he found artwork of human figures with an emphasis upon eye and eyebrows were pinned to corkboards. Interview on November 17th. 4 days later, DM was interviewed by Detective Gooch and indicated that she was really asleep and probably very drunk when she woke up at 4 a.m. This all comes up on cross-examination. Throughout the interview, DM expressed uncertainty about what she heard and saw and did not know if it was real or if it was a dream or if her mind was playing with her. It just doesn't make sense. I mean, I imagine in trying to recall this evening, none of this makes sense. DM described the intruder and told the detective that she recalled seeing his eyebrows, his bushy eyebrows, but did not recall the color of the eyebrows. This was on November 3rd. No, this was on November 17th. When she saw the intruder, she thought that the intruder was about 3 feet away from her, but could be off since she was still a little bit drunk. She did not think she could remember enough to give a composite for a composite artist. She could just recall the bushy eyebrows, but not the shape or color of them. In the interview, the detective asked if DM had any anxiety, which led DM to stating that she had a lot of lucid dreams of being kidnapped or chased. I imagine that after this, there was a lot happening. She indicated that she watched Criminal Minds and fell asleep to crime podcasts. I imagine that changed after the fact. These lucid dreams began in high school. On December 1st, 2022, a month and a half later, DM was interviewed again and described the intruder. She did not see his eyes, but saw one eyebrow or two, but it was just like this bushy eyebrow. I could just see like an eyebrow, this bushy eyebrow. She did not remember the color or the shape of the eyebrow. She just remembered it being bushy. She did not remember if she saw one or eyebrow or two. Throughout the interview, DM indicated that she had always had really bad dreams, lucid dreams, and scary dreams. Don't fall asleep to crime podcasts then. That seems, if it impacts your dreams, maybe the Calm app. There's lots of stories on the Calm app about like trains and what you see from the trains. She did not know what part of her recollections were dreams and what part were real. And that's your cross-examination. When she woke up in the morning, she did not fully understand what was a dream or not. In this interview, she indicated that she thought that the person she saw was a fireman. All cross-examinations. On December 29th, a statement submitted by law enforcement in support of the arrest warrant used descriptive information from DM's interviews. DM described a figure as 5'10" or taller, male, not very muscular, but athletically built with bushy eyebrows. Well, then that must have come from some interview, because if it didn't, that's going to be a problem. But the motions to suppress the warrants were already denied. On December 30th, 2022, after the arrest of Kohberger, DM was interviewed by detectives. When she learned an arrest had been made, she found a mugshot of Mr. Kohberger online. When asked if Mr. Kohberger was the person she saw in the house, she said she did not know if Kohberger was the intruder. She knew that the intruder had looked at her because of the bushy eyebrow. All she remembered was some bushy eyebrow and all black and some sort of mask. Grand jury testimony, May 15th. I'm surprised this isn't redacted. Subsequently, DM provided grand jury testimony and was questioned about what the intruder was wearing. She was uncertain, and the testimony is attached but not quoted verbatim. Oh, it is redacted. Well, I appreciate that. Reliability of witness identification. And this is hard because we're not really in an identification. We're in a description. So they're going to go through the elements of the opportunity of DM to make an identification. And this is for the defense, and we're going to zoom real quick to what the state says. But she's not really identifying Kohberger, and the defense is making the argument that saying that he had bushy eyebrows is akin to an identification, and therefore she should not be allowed to use those descriptors because there's too many questions around that descriptor. And so it is akin to a identification. For reasons addressed above, Kohberger respectfully requests this court grant his motion in limine to exclude DM from using the words bushy eyebrows to identify the intruder she saw, and to exclude her from identifying Kohberger based on bushy eyebrows. Like, she can't sit in court and be like, well, that dude's got bushy eyebrows. And I think that's fair. I'm going to pull up the state response to that real quick. because the state responds saying, I think essentially this is for the jury to decide. So let's pull that up real quick as I am running late, but so this, again, a lot of this is just going to be for cross-examination. The opportunity to see, to perceive, to hear what happened earlier in the night, whether she had fallen asleep, had not, like all of that is going to come up in cross-examination. Let's see. This is the state's response. The state says, applying the Idaho rules of evidence to the facts of the case at hand, the court should find that DM's descriptions of the intruder, including that he had bushy eyebrows, is admissible. The state incorporates the previously filed motion to limine regarding the text messages as well as the 911 call into this response. On November 13th, 2022, sometime before 4:19 a.m., DM observed a person inside her residence, which she shared with her 4 roommates. DM placed several phone calls and sent several text messages to her roommates. The only roommate who responded is BF. They had 2 short phone conversations. Within those phone calls and text messages, DM relayed to BF she saw a person in the residence wearing black and he had on a ski mask that covered his forehead and mouth. On November 13th, a 911 call was placed for report of an unresponsive female. At 11:56 a.m., the caller stated that one of the roommates was not waking up. The caller stated, oh, and they saw some man in their house last night. The same day at approximately 12:09, Moscow Police Department responded and took a statement from DM on scene. And she told the officer that she saw a male, not insanely tall, wearing all black and a mask that was just covering his forehead and mouth. He's a little bit taller than me. I couldn't really see much of him. I'm almost positive he was wearing a full black outfit. He had this mask that was just over his forehead and his mouth. DM gave the description a 3rd time, repeating that he was wearing a mask, that he was an inch or 2 taller than her. He was basketball player kind of skinny. And a voice she did not recognize. The same day at approximately 1:47 p.m., DM was interviewed at the police department by Detective Mallory. During this interview, DM reported she saw a white male. She did not know, maybe my height, a few inches taller, skinny, athletic build, wearing all black, wearing this mask that just covers his forehead and here. That's probably video recorded, so you can see where here means. Regarding his height, she reported, I'm 5'10", so he's probably about 6 foot. I don't remember what his eyes looked like either. I didn't recognize eyes, but he's definitely a white guy. A few days later, on November 17th, DM was interviewed at Idaho State Police by Detective Gooch. DM gave a detailed recounting of what she did on Saturday, November 12th, until she went to bed at approximately 3:20 a.m. Let's see. Sometime between 4 and 4:20, DM woke up and heard a male's voice, a voice she didn't recognize, saying, it's okay, I'm going to help you. DM opened her door and saw, quote, someone, because like from my mind, it's like I was almost wearing these like blurry glasses, like it's fuzzy and cloudy, but it was like a figure of someone wearing all black. And it was like they had a ski mask and was covering their forehead and their chin and mouth. And I could see all I remember was seeing their eyebrows. I don't remember what their eyes looked like, but I remember their eyebrows. I just don't know the color the eyebrows were. I just remember like bushy eyebrows. That's all I could think about. I think this will go to cross-examination, not to keeping her from making the description of what she observed. They quote the same stuff the defense quotes. DM recounted calling and texting her roommate and discussed with BF that there was someone in the house wearing all black and a ski mask. That contemporaneous utterance is going to matter because it's consistent with what she said later. For those of you in the chat saying the cross-examination of the surviving roommates will be vigorous, it will, and probably uncomfortable to watch. But that is, trials are adversarial. The detective explained to DM that the important thing was to tell only things she knew were true. That's the most important. And the detective acknowledged DM's trauma. The detective confirmed facts from DM's memory again. DM reiterated she saw a male figure in the hallway approximately 3 feet from her. He was holding something. He was wearing all black clothes. His forehead was covered. He was wearing a mask. And she remembered his eyebrows. And then they go through the other statements saying her statements were arguing essentially her statements were consistent. And this is, she's allowed to describe what happened. This is not her saying that person sitting here matches this description. This is her saying, this is what I remember seeing. This is what I said in all of my contemporaneous interviews. And this is what I said when I, that night, was on the phone with my roommate. And they go through quite a lot of additional interviews. And let's see. Unfortunately, I do not have time to finish this. I will read this tonight before we get into these arguments tomorrow, because they did put quite a lot of law in here. I'm interested in how the state is parsing the difference between the description and eyewitness identification, because it's not truly an identification. In conclusion, the state requests that the court rule consistently with its previous findings that DM is credible and competent to testify. Yeah, most of that goes to cross-examination. Allow DM to testify at trial regarding her recollection of the male she saw in her residence during the early morning hours, and as having bushy eyebrows, because this evidence is relevant and admissible. And they included the selfie taken from Kohberger to have admitted so the jury can determine how Kohberger looked closer in time to this, because this, let's see, this selfie, and they put in his driver's license too. This was closer in time, because I think it was later that day. Hold on. Where do they say it? Let's go to where they talk about the photo in this. Let's see. Nope, photo lineups. That's not it. And that's not it. There's got to be other discussion of that when that photo was taken. There it is. Let's see. Mr. Kohberger, the defendant states Mr. Kohberger does not have bushy eyebrows. The state intends to introduce a photograph of Bryan Kohberger taken from his phone on November 13th, 2022, only hours after the homicides at 10:31 a.m. Whether or not Bryan Kohberger can be described as having bushy eyebrows is a factual determination to be decided by the jury. So they are going to ask to introduce the photo to show his build, his driver's license to show his height, and the photos to show what his eyebrows looked like the next day of. Like, is that someone who is athletically built? Can the jury determine if those are bushy eyebrows or not? How tall is he? Is on his driver's license at 6 foot. So that is what they are going to be introducing to say that DM's description is consistent. The defense is saying DM's description is unreliable, so it should not be allowed in with regard to particularly the bushy eyebrows. Again, I think this is for cross-examination. I think this should be in front of the jury for them to decide. I don't think you can block the statement and multiple statements of this witness, and that will be cross-examined. Unfortunately, I am running way behind. Way behind. And so when we get to tomorrow's court hearing, I believe I'll be streaming at 10 a.m. or a little after 10 a.m. Central. I will let you know in the Law Nerd app today what time, maybe 10:15, maybe 10:30 tomorrow morning. But we will be covering these hearings tomorrow, and they are going to go through as many of the motions in limine as they can and then continue on Thursday. I'm sorry I did not get to more questions today and to super chat. I wanted to get through some of these motions in limine, and then the tech motion in limine, because I went through it with y'all in real time. The tech motion in limine, I was like, what in the world is happening here? Because, woof, I need to parse through the tech motion in limine again, because I still have questions about it. As to the bushy eyebrows, I think it's for cross-examination. As to the state's motion in limine saying the defense can't say this record existed, I think that's for cross-examination. If you had known this within 7 days, could you have gotten it? Yes. Okay, but did you know it within 7 days? No? Okay. I think that is absolutely fair for cross-examination. I would be surprised if the court blocked it, but I want to hear more about that window of 7 days and see how that's attributed. So I need to go back through those with a fine-tooth comb. I will give you a bit of my thoughts on what I take away from that before court tomorrow morning. To everyone who gifted memberships today, thank you so much. Chronic Shocks Art Journal and B2, thank you for all the gifted memberships. To the new members, welcome. Enjoy not having slow mode. We are going to be in court the rest of the week. I am going to go through and, again, look at some of this before court. I'm sorry that we did not get to more questions. I really wanted to get through some of these motions, and I really wanted to update the TikTok psychic case because I think it's important. So I'm sorry I didn't get to questions, law nerds. It's a busy day. So we will talk to you guys tomorrow. We'll be in court tomorrow. Law nerds, take care. Thank you. And I will see you tomorrow. All right, let me roll the outro. Get the Law Nerd app. Thanks for being here. Thanks for being a Law Nerd. We have court tomorrow, everybody. Get ready for court. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.